good, because I didn't think about the fact that I used to just throw my keys to them because they always put it over the door.
Oh, okay. Well, good. At least I was thinking.
Yeah, it just really threw me into a.
Okay. I appreciate that. If you don't mind, 'cause I have a-
Messed me up.
It's all right.
Okay, thank you.
Not having keys, you're not having my receipt.
Another receipt. Yeah.
Is Mike here? I haven't seen Mike.
Mike's here.
Okay. Do you need me? I didn't.
I don't want you to.
Oh, no,
Your train of thought.
no, no.
Have you signed up for this government program training yet? Okay.
Is it coming due?
Shoot. Okay.
Okay.
It's from it's they have it's you got August to August 31st.
August 31st. Shoot, I'm out of town.
It's
Okay.
it's really it's a webinar. It's like it's
Right. I like the
PowerPoint.
worst. Yes.
It's
I
like
know.
PowerPoint.
So I can do it at
Yeah.
home. Okay.
It's like 30. I think
Okay.
it's like 30 minutes.
Okay.
But
So when's the
but
next
I can-
one?
It's any day. It's 24/7.
Anytime?
It's
Okay.
24/7. So whatever
Okay.
day.
I come back on the 15th, and then, let's see, how about, I'm leaving on the 18th, so let's do the 17th.
17th.
Okay.
Okay, and I'm gonna send you an email.
Oh, wait, I get to the 31st, hold on a
You get to
second.
the 31st.
So let me see, oh no, then I've got a wedding, I've got a thing, yeah, okay. So we are gonna keep that at the 17th, that's literally my last day, look at that, nothing on that day. Okay, webinar, okay. And would you be so kind as to send me my links or whatever?
Register yourself. Names, I'm gonna send
Would
you
you send to
everything.
my regular one rather than my TDLR? D-U-R-K-at-AOL.com. Perfect, thank you.
I'll do
Okay.
that.
And I'm a C, not a K. Okay. Okay. I'm gonna send it to you now, I didn't get it. Okay. Okay, I'll do it, I promise. Thank you. Got a favor to ask you? Mine's been living in the shop, so I'm pretty sure I'm up to date. I haven't gotten any notices. Do you want? Okay, if you need to take it, that's fine. Do you want me to leave it here when I leave? That's fine. Yeah. Oh, you mean to open it up? Yeah, I do, yeah, because I just have to change it. So yeah, I can do that. And then, can I bum a plug? I usually end up buying. I've got the link, but I just forgot to grab the long part.
And I was gonna ask you, on mine, okay, so I don't think TDLR allows us to get on the Apple. Can we get?
The iTunes
Yeah.
account? I don't know if we set y'all up for iTunes accounts.
Are you using this for everything?
No, I'm not. It just sits in my bag all the time.
Oh, me too. So you're listening to music?
And I thought that while I was at the airport or something, I could do something useful.
You're so
You know.
cute.
So I thought, is there any possibility? Yeah. You know, like, good, but I wanted to watch a movies, you know? You know what I'm saying? I mean,
Know what I'm saying? Sounds like we are the Millers. No regrets, not even a letter.
exactly.
Where is?
See what you
I missed it. I'm sorry I missed it.
I think you may be right.
I'll put my password right here.
That's what I was planning. Yeah, I was gonna have him come up and do his explanation of whether or not to start, okay? What's your concern? Yeah, into the motion. And I'm just gonna say that after our discussion, we decide to amend, the motion, to the proposed plan. So my motion is gonna be, I wouldn't, yeah. Uh-huh. Yeah, exactly. It didn't have to be long. Okay, you want me to do that way? Okay. Okay, sounds good. I'll do it. Okay, okay.
Nice to meet you, Robbie Shaw.
Well, so, how you doing in your settlement? Is that right?
Thank you.
Yeah.
Thank you, thank you. I know, it's, can you get it? Can you see it? I actually have plenty of power, but I just figured, just in case I go under.
Is that right?
I don't have one. Well, it might help me. I might do better.
So I
You had
said,
somebody help. No? What are you? Okay.
and
No.
I've been busy, I said I'm almost to square one, where I should have been starting. Good morning.
Hey, good to see you.
My starting point.
Is that right?
Figured out where I would have started when I bought it, yeah.
Did you get that picture I sent?
Yes, I did. I
Got the
love
new
it.
shower in it, and
We got it framed and ready to go.
Did you really? Good for you.
What do you have? What do you think? What do you think?
I've noticed it how battered, bruised, scratched up.
You are, you gotta be, huh?
Yeah, yeah, I look pretty beat up.
Tackling that, huh? Wow, that's something. That's right. That's why. Okay.
You been?
I'm doing
Good,
good.
eh?
The girls doing okay?
Everybody's doing great.
Take any time off this summer?
No, we're gonna do
Yeah.
it. We're gonna do it at the end of the August.
When it started out getting sunny, and I said, then it would flash flood, and then the sun would come back out, and then it would flash flood. Wow. And I said, it was the biggest mess.
It's gotta be something you can work with. Still, you just gotta, sometimes you just have to get started, bro. You gotta get it done, you know?
I work all day.
Comes out of like,
Isn't that funny?
No.
Oh, we need to move the August thing to the top of the agenda so we can get them out of here.
That's what I told them right now.
Okay.
That's like, we're gonna get you out of here because I gotta get you off the clock.
I know.
well, you know,
Yeah.
Keeps you better.
it's good. I'll tell you this, you know, the summer and things are just going on. It is, really is.
That's our thing. Is that what the deal is? No, I think it's because Bill's mad at me.
No, I'm serious. That's not it.
Okay, but let me see if we're gonna follow by following line, if something's wrong. Right. So now we know where to go.
Yes, sir. Are we ready? Before Before we get started, I've asked Commissioner Butler to lead us in a prayer. Commissioner Butler.
Dear Lord, thank you for bringing us together safely here. Please watch over us and guide us as we go about the state's business. Help us make the best decisions we can. Please provide for our safety as we head back home, those that are on the commission and those that are visiting us from various parts of the state. Watch over all these proceedings and guide us by your gentle and loving hand. We pray these things in your name. Amen.
Amen. It is 8:11, and this meeting will come to order. Ms. Mayhound, if you could call roll, please. Present.
Present.
Julianne Morgan,
Here.
Fred Moses,
Here.
Catherine Roosevelt,
Here.
Robbie Shaw,
Present.
Deborah Yurko.
Present.
We do have a quorum present with us. Commissioners, I am going to be kind of bumping around today, so I'm going to ask you to kind of keep up. We have several agenda items that we have to cover, and due to the fact that we canceled our June meeting, everything's kind of been rolled over into this meeting, so we got
a little rain.
Yeah, a little bit of rain. I think Bill was coming after us or something. This tropical storm Bill, of course, I meant. So I'm going to be jumping around. At this point in time, what I'd like to do is to jump to item F, which is the discussion and action plan for the audit. Approval of the audit. So I think there was a finance audit meeting this morning.
Yes, sir, there were. I'll go ahead and address that.
Please.
This is Deborah Yurko. I'm head of the audit committee. We met with Garza and Gonzalez Associates, who are our auditors for the TDLR, and they presented our audit plan for 2015. We did want to just kind of put it on the record that it is July, and we are just getting to this at this point, primarily due to some staff changes. But they have assured us that we will still be able to get the audit filed on time as required. And if anyone has any questions on the committee regarding that, please feel free to ask them at this time as they are here and present. Assuming there's no questions, they did present a plan to complete the audit. We decided to make a couple amendments on that. One was to include the elevators and, let me get that back up. The elevators, escalators, and related equipment area to the audit in place of the architectural barriers. But I think we were gonna, I'm sorry? Oh, no, you're right, in the information systems.
You want to go ahead and come on up so you can kind of maybe
Yeah.
address questions as they're being asked.
Right, Mr. Chairman, I've made the suggestion that the IT audit could be pushed back to another date. We just completed the Gartner audit of IT last year. That recommendation from Gartner was also part of the legislative appropriations request that we did receive funding for, so we're implementing those recommendations from Gartner now. So I think it's more appropriate, instead of duplicating what the risk factors are that Gartner identified, to, at a later date, identify the progress that we made in addressing those risk factors. So I think that it's a better use of our audit resources that way.
So we're moving the IT and bringing up which one now?
We are removing, sorry, Commissioner Yurko?
Go ahead.
This is Kim Gonzalez with Garza Gonzalez and Associates. As Commissioner Yurko indicated, the areas we were recommending in your audit plan as it states right now, it was the information systems and the architectural barriers program. Based on the discussions that occurred during the Finance Committee meeting, it was agreed both by management, the commissioners, and ourselves that we would remove the information systems, forego the information systems audit this year, and perhaps consider it when all the other items have been implemented, and then take the elevators program as part of the audit for 2015. So with that, we would do the architectural barriers and the elevators program during the 2015 fiscal year.
Commissioner Shaw.
Yeah, so I did have that same question, Bill, that why we were doing the information system at this point when we already did a previous audit of the Gardner system. So I think you've answered my question. What is your basis of going with the elevators and not going with any other program? What's the criteria? How did you select that to be the one that needed to be audited?
If you, the risk assessment summary on the last page, it breaks up the 33 auditable areas between high, moderate, and low risk. We were recommending the second and the fourth area for the audits, and I believe since the information systems, as indicated, had already been audited, the elevators was the one that came up to the next high risk. That was the area that is the highest risk after the other ones, and based on the concerns of the commissioners, I guess there have been some concerns on the elevators program, so that's how that escalated to the next level.
And also to answer your question, the enforcement administration fines and penalties had just been addressed 2 years ago.
Any other questions for the auditors?
And I think all those programs are part of this high-risk, they're part of the high-risk exposure in the audit plan, right? They're considered high risk. So all the programs that we're talking about, so any of the ones that we select as were audited in the audit plan this year is part of that.
We're high risk. Mm-hmm.
Yeah.
Yeah, I just wanted to make sure that we clarify on this. My question was more for the audience than it was for anybody else. So we all understand, the risk assessment is not based on the severity of the program, but more to do with the financial side.
That is one of the risk factors.
risk factors.
There are 8 risk factors. One of them is the financial materiality, but another one would be time since the last audit, the results of the last audit, and so on and so forth. So it is one of the criteria, but not just, not the only criteria, yes.
Good, thank you.
Any other questions? I'm sorry.
No, is there? Okay.
Oh, good.
Brad, do I need to make a formal motion to adopt the internal plan as amended?
Yes, we
Okay.
do, this is Brad Bowman, General Counsel, we do need a motion and vote from the commission to approve the final audit plan.
Okay, then I move to adopt the final audit plan as amended by including the elevator, escalators, and related equipment in place of the information system security and disaster recovery.
I'll second that.
We have a motion and a second. Any further questions? I want to thank Garza and Gonzalez Audit Firm for helping us and stepping us through. Also the subcommittee, which I believe consists of Commissioner Yurko, Commissioner Moses, and Commissioner Morgan. So all in favor signify by saying aye.
Aye.
Those opposed? It's adopted. So thank you. You're now off the clock.
We're off the clock.
Yeah, right now. Officially off the clock now. Thank you. Appreciate it. Let's go back up to agenda item E, approval of minutes. Commissioners, I'm sure you probably had a chance to review the minutes. Motion would be in order.
So move as recommended.
Second.
We have a motion and a second. All in favor signify by saying aye.
Aye.
Those opposed, motion carries. We'll now move on to the rules. I'm sorry. Let's move on to item I, which is the approval of the award of the contract for the examination services. And then from there, just so the audience and the staff knows, we'll move on to rules.
Good morning, Mr. Chairman, General Counsel. I'm Ray Pizarro, Director for the Education Examination Division. Today I'm before you to seek the approval for to award the contract for the examination services to PSI. The department issued an examination request for proposal back in February 25th of 2015. The deadline for that proposal for all submissions was on May 4th of 2015. During that time, we selected a group of evaluators to review all submittals, just to ensure that the group that we selected was a good representation for the various divisions around the department. The goal was to ensure a fair assessment for those who have submitted a response to the examination request for proposal. On May 30th, the evaluators completed their assessment, and on June 1st, the General Counsel, Financial, myself, and met with Bill and Brian to provide them with the department's recommendation that the vendor PSI can fulfill the statutory obligations under the Texas Occupational Code to provide minimum competency examinations prior to the issuance of a license in the state. In addition, we found that the recommended vendor, PSI, was able to reduce examination fees across all license type up to $250,000 per year. So the lowering the cost is consistent with TDLR's philosophy in saving money for our licensees. So today I'm asking the approval to us to enter into contract with PSI. If you have any questions, I'm here to answer.
Any questions for Ray?
So moved.
I have a question.
Yes, we have a motion on the floor.
On this PSI solicitation, was there any discussion during the evaluation process for expanding for future programs that are oncoming?
Yes, within the proposal, we left that open, that if, I can't remember the exact wording, but we have it left open if any new programs are put under the umbrella of TDLR, that contract that was awarded to the vendor would have to fulfill the obligations of administering those exams.
Thank you.
So it'd just be piggyback on top of it?
Correct.
Right, and the way it works is the vendor has seat time as the determinant of what the cost of the exam would be. So if you have a 4-hour exam versus a 2-hour exam, the 4-hour would be twice the cost because it's based on that seat time to take the test, depending on how detailed that examination is.
My concern was just I didn't want to go out there and get into a contract, and then suddenly we have 3 other programs that come on board and we can't piggyback
Right,
them
we,
on. So.
we need that flexibility. We were watching
Yeah.
out for that.
And this contract, by the way, goes into effect September 1 if you approve them.
There's a
September
motion.
1?
Yes, sir.
I think there's a motion on the table. Mr. Chairman, I'll go ahead and second it.
We have a motion and a second to approve PSI and award the bid to PSI. All in favor signify by saying aye.
Aye.
Those opposed, motion carries.
Thank you.
Thanks, Ray, I appreciate it. Let's move on to item J, which is the rules concerning the technical zone and combative sports. How are you, sir?
Morning, Commissioners. For the record, Charles Johnson, Assistant General Counsel. You have in front of you a proposal to amend the combative sports rules at Chapter 60, and 61, I'm sorry, .10, and to delete 61.40. The purpose of the amendment is to clarify who has access to the technical zone. And as you recall, the technical zone is the area between the end of the apron and the barrier between the spectators. The existing rule defines the technical zone as a alcohol-free barrier area. We wanted to clarify not only is it an alcohol-free, but it's a working area, and it's designated for specific personnel. And the rule goes through the list of people who are authorized to be in that area. And in summary, it allows access to the medical personnel, the ringside officials, promoters representatives. It allows access to managers, contestants, and agency staff who are assigned to work the event. It also allows access to members of the media and the sanctioned bodies for the combative event, the sporting event. It also allows access to security personnel and to individuals with regulatory oversight. That is the exhaustive list of people who are authorized to be in that area. I'm sorry, I neglected to say the ring card staff. It was a kind of a politically correct way to refer to the people who signify to the audience what round is coming up. So it also deletes the section 61.40, which would creates this secondary overflow area that theoretically reduces the number of seats available to the audience. And so we've kind of tightened up who has access to that technical zone. We kind of looked across the country to other commissions, other athletic bodies, and we believe that the rule that we've presented to you today is the most restrictive of those bodies that create a technical zone. We received one comment from a person who wanted us to amend the rule to allow or to require that the managers be paid at the end of the event. That was outside the scope of the rule, and so we made no changes to address that one comment. We're asking you to adopt the rule as published without change with an effective date of September 1, 2015. If you have any questions, I'm ready to answer.
You have any questions for Charles?
Chairman, I make a motion to go ahead and adopt as presented, making the rules effective September 1st.
Second.
We have a motion and a second. Real quickly, Charles, the end, as you said, the technical zone, end of the spectator area to the barrier. Now, that's kind of a fluid area depending on the size of the event.
Yes, sir. From the edge of the apron, the edge of the ring to the barrier that separates the zone from the spectator area, it kind of fluctuates based upon the size of the event, the venue. Staff kind of surveys the area in advance. They meet with the promoters and they agree upon the size of that area and exactly how many seats are going to be in there. So it's kind of a fluid, but we wanted to define the parameters of who has access to it.
And the seats within the technical zone, because of the fact that it is a part of the rules, are basically a no-value type.
Yes, sir.
Those seats in there because they are reserved for staff, those that are working, all that. So there is no value in those seats.
No, sir. And that was one of the things we want to kind of clarify. There's no value. It's a working area, and by definition, only certain people are allowed in that area. If they're not working, it's restricted.
And you said that those that are authorized would also be regulatory oversight authorities.
Yes, sir.
Which would include elected officials and those that are would be able to dictate certain statutes to this particular sport.
Yes, sir. It just makes sense that if a body has authority to pass rules, statutes, regulations, whatever official capacity they function in, that they would have access to the area so that they can actually observe and make real-world decisions based upon what they've actually seen and experienced.
I think this is probably a good way or a good tightening, because as we begin to start having more and more mega events in the state of Texas, along with the numerous events that take place on a weekend, at any point in time, I think we could potentially have 4 or 5 events in a weekend.
Yes, sir.
So it helps to be able to start defining and tightening up what we're allowed to do there.
And we believe that this rule accomplishes that purpose.
Thank you, Charles. We have a motion and a second. All in favor signify by saying aye.
Aye.
Those opposed, motion carries.
Thank you, Commissioner.
Thank you, Charles.
Let's go on to K, which is the rules concerning the property tax consultants. Good morning.
Good morning. Lynn Latome, Assistant General Counsel. This agenda item is a discussion of possible action to amend 6670 of the Texas Administrative Code to update our internet address. As you know, TDLR updated or changed their internet address to, and this is my commercial, I'll look at the camera, to tdlr.texas.gov. 6670 changes the registrant's responsibility to listing on their contracts from the old email address to the new email address. This was posted in the Texas Register for 30 days of comment, May 15th, 2015. Comment closed June 15th. We received no comment on this rule amendment. The department recommends that you adopt the rule amendment with an effective date of September 1st, 2015.
Any questions? I don't know if you've had a chance to look at the website, but it's a really great-looking website now.
And I may be fuzzy on this, but it just dawned on me here to ask, so I didn't really go through on this question I'm going to have for you. I know it changes a lot of the requirements for different licensees on their contracts. Do we have a requirement that they have to do it right away, or can they use the documents they already have?
The effective date is September 1st. The department will not require any registrants or licensees to use that on their documents until December of this year.
So we give them 3
So
months.
it'll give them a little extra time to
Sure.
use up any supply of forms they have pre-printed.
That's great.
Thank you. Motion be in order?
Second. So move as recommended.
I'll move.
Okay.
You get moved and
Motion and a second.
Okay.
However y'all did it, we got a motion and a second.
Yeah.
That's right.
All in favor signify by saying aye.
Aye.
Those opposed, motion carries. Thank you. Move on to item K. Oh, I'm sorry, that we just did K. L, which is the IHB program.
Morning.
Morning.
Della Lindquist, Deputy General Counsel. Essentially, these rules were developed by the Code Council here to address a very narrow situation in which perhaps an uncertified manufacturer, there's an immediate need for some housing or some buildings in a specific situation. And currently in the rules, there's a place to address that, but it's kind of vague, and it didn't really address under what specific circumstance or situations it might be appropriate for the executive director to issue the waiver or authorize these special kinds of situations. So the rules were amended to propose several narrowly defined situations in which it might be appropriate to do a 100% inspection on an uncertified or unregulated manufacturer to make sure that every component is done the correct way, but it's kind of a one-time thing, certain disasters and things like that. So there were no comments on these rules that were proposed. They were proposed in the Texas Register on May 8th, 2015. There was also some cleanup language that were in the rules that we needed to correct some editorial changes. We did not receive, again, any public comments. The comments closed June 8th. And we recommend adopting the rule proposal with an effective date of November 1st, 2015. Answer any questions.
Any questions for Dell?
So move as recommended.
Second.
We have a motion and a second. All in favor signify by saying aye.
Aye.
Excuse me. Those opposed, motion carries.
Thank you.
Thank you. Now let's go on to item M, the rules concerning electricians.
Lynn Latome, Assistant General Counsel. This is a similar rule adoption that from the PTC that we just saw a moment ago. It's updating the web address to the new address as adopted by TDLR. This amendment to 7351, 7352, and 7354 of the Texas, Chapter 16 of the Texas Administrative Code was published in the Texas Register May 15th. Comment closed June 15th. We had 7 comments ranging from agreement to concern over the use of pre-printed forms to disagreement. Again, the department, in receiving those comments, has made the determination that the effective date will be September 15th, but any pre-printed forms will be allowed to be used through December of this year to help alleviate any impact on people's businesses.
And that's December 31?
Yes.
Yeah. Right.
Yes. The department recommends adoption of this rule with effective date of September 15th.
Any questions?
So move as recommended.
Second.
We have a motion and a second. All in favor signify by saying aye.
Aye.
Those opposed, motion carries. Thank you, ma'am. Now we'll move on to item N, which is rules concerning air conditioning refrigeration.
Good morning, Wendy Pello, Assistant General Counsel. Agenda item N is the proposed amendments to the administrative rules under Chapter 75 regarding the air conditioning refrigeration program. And again, this is a change to update the department's internet address, and specifically the change is being made to Rule 75.71, which requires the department's internet address to be included on proposals, invoices, written contracts, and on certain signage for the air conditioning refrigeration program. As previously stated in some of the other rules, the proposed rules were published in the Texas Register on May 15th, and the public comment period closed June 15, 2015. We received 4 public comments in response to this proposal. You have copies of those comments. The department is not recommending any changes based on the comments to the rules. though we are recognizing and adding some clarification. The preamble to the rules stated the department would allow businesses to continue to use existing forms that had the old internet address on there through December 31st, 2015. Based on those comments that were received, there were some concerns about using up their current invoices and having the cost of having to print new forms. Just a clarification on that is that the department would allow those businesses to continue using the forms after December 31st, 2015, but they would have to cross off the old internet address and they could print that on there. So hopefully that will alleviate any concerns about the cost. So that's just an additional clarification, but it doesn't change the rules. It'll just a little clarification on how it will be implemented. So we are proposing the rule adoption for an effective date of September 1st, 2015.
So,
Have any questions?
I guess the other question is, when, but they could cross through that, can they cross through that address forever? Or is it
Well, there's not an end date, as long as, I think the requirement really is that they need to be giving the consumers the updated internet address. So recognizing somebody may have several years of that, but as long as they're providing the accurate information.
And doing that.
Right.
Yeah,
So that's
as long
kind
as
of,
they're doing that.
right, but again, they will have to be
Eventually,
using that.
eventually, yeah.
Right, but they will always, come December 31st, they're going to have to be using the correct internet address. So.
I guess this question is for Bill. How long have we had the new internet address? It's been a while, hasn't it?
It's been quite a while. It's probably about 9 months now.
Okay. I was going to say it was probably closer to a year, but I guess that's right.
In fact, it's even longer than that. And the way things were going, everybody was supposed to be converted by now, and for some reason, it's not
It's taking forever.
universal. There are some state agencies that are still using the old .com address, but we've been on the .gov for quite a while.
And I guess that's probably a good point to make, that this has actually been mandated to us.
That's
Is that
correct.
correct?
And part of that was that our URL of license.state.tx.us, that word license was coveted by others in state government. So we had to go to the TDLR to give that up.
Okay. Motion to be in order?
So moved as recommended.
A motion?
second.
A second. All in favor signify by saying aye.
Aye.
Those opposed, motion passes. Thank you.
Thank you.
Let's go to item O. It's a rule review for service contract providers. Oh, I guess you're still here.
It's still me. Again, Wendy Pello, Assistant General Counsel, for the record. Yes, this is the 4-year rule review for the service contract providers and administrator rules. As required by Texas Government Code, Section 2001.039, state agencies are required to go through this review every 4 years to make sure that the reasons for initially adopting the rules continue to exist and that the rules are still essential and necessary. The department has reviewed the rules for the service contract provider and administrator program and has determined that the reasons for adopting the rules continue to exist and they're still essential for implementing Texas Occupation Code Chapter 1304. The notice of intent to review the rules was published in the Texas Register on March 20th, 2015, and the public comment period closed on April 20th, 2015. The department received 2 public comments in response to the notice of intent to review. You have copies of those comments. Both of those comments involved statutory changes, which is something we couldn't do through the regular rulemaking process, but can't do through a rule review either. So the department at this point is recommending that the commission re-adopt the rules at 16 Texas Administrative Code, Chapter 77 in their current form with an effective date of August 14th, 2015.
Any questions?
So moved.
We have a motion and a second. All in favor signify by saying aye. Those
Aye.
opposed, motion carries.
Thank you.
Thank you, ma'am. Let's go to item P, which are the internet address for polygraph examiners.
All right, well, this is my last one. Lynn Latome, Assistant General Counsel. Again, this is another rule filing to update the internet address. This is for Chapter 88 of the Texas Administrative Code, 8878, updating polygraphs forms to the new internet address. This rule proposal was published May 15th 2015. The comment period closed June 15th. One comment was solicited, and that comment agreed with the rule change. The department recommends adopting the rule amendment to the existing rule at 16 Texas Administrative Code, Chapter 8878, regarding the polygraph program.
Any questions? Motion be in order.
Second.
A motion and a second. All in favor signify by saying aye.
Aye.
Those opposed, motion carries. Thank you, ma'am. Let's go to item Q. Same thing, internet address for the Dogs and Cat Breeders Program.
Commissioners,
So I guess if I had known who was going to be doing this, I could have called them all at one lump instead of bringing you back up and forth.
now I'll make it easy for you. What she said. With one twist. We received 3 comments. 2 comments. One comment addresses a licensing issue, which is outside the scope. A second comment addressed the reselling of puppies, which is also outside of the scope. But we referred those issues to the divisions to respond to the commenters. We had another comment which kind of confused, and because the internet address applies to the contracts, and the comment was addressing advertisements, and so that again outside the scope of the proposed rulemaking, and the comment would not be affected by this change.
Okay. Any questions, commissioners? Motion be in order.
So move as recommended.
With an effective date of September 1st, I believe.
Okay.
Thank you.
Motion and a second. All in favor signify by saying aye.
Aye.
Those opposed, motion carries. I think that takes care of all of our rules. We
Mr.
went through
Chairman.
that a lot quicker than what I was expecting.
Mr. Chairman, it's Brad Bowman, General
Yes, sir.
Counsel. It was brought to my attention that on item M, the electrician rule, what was stated on the record was an effective date of September 15th, but what we were actually recommending was September 1st. Could we revisit that if it's appropriate
Need a
to?
motion to
just-
reconsider?
Yes, please. Apologize for that.
Second.
Motion and a second to reconsider item M. All in favor signify by saying aye.
Aye.
Those opposed, motion carries. So we're now looking at the date being September 1 as opposed to September 15th.
Correct, to adopt the rule with an
So
effective
could we
date of
get a motion in that order?
Motion to adopt the rules of, by September 1st of this
Second.
year.
Second.
And we have motion and a second. All in favor signify by saying aye.
Aye.
Those opposed, motion carries. Thank you, appreciate that. Brad, I think we're going to go ahead and go into executive session now to consider. Let's go ahead and go into executive session, consultation with staff attorney pursuant to 551071 of the Government Code, to receive a briefing from general counsel concerning pending or contemplating litigation. Also to enter into 551072 to receive consultation and advice from general counsel on legal matters. And 551074, discussion of personnel matters.
Leaving again?
Sorry?
We're leaving again?
Well, we're fixed to go into executive session, but this lady right here in the yellow, she can help. Thank you. Yeah, yeah, she can help you.
I didn't realize exactly what was coming up. Now, are you here for a motion? Okay, all right, so, and what was your name? Okay. So, executive session, normal, about 30 minutes, and they'll come back on record and probably start with the contested cases first, which there are 12. That's good. Better part of a couple hours, maybe. Okay, I think so. All goes well. Yes, yes. It just tested to make sure that the grading was good and everything. It's got a.
talked to David. The same place?
Unlike most buildings where you have a floor, not a floor.
Yeah, there's only like 3 openings.
Which probably adds to the.
Yeah, it's the same as we're using in Dallas. You know, they're supposed to have access openings on the doors every 3 floors, but the code says only if you need to accomplish that. So in other words, if you have a tower with a staircase, then you can put those access openings. If you don't, it's like 2-way communication, which is a problem. Which every elevator has in it.
Okay.
Everything's good if you own it.
But you know what they call the contractor out this time, data centers out there? Or they call it fire department?
It doesn't really say, it says the fire department that the people have. So whether they, and that's, you know, what the people make it, I mean, the longest was 2 hours. He said, why would that work? Yeah. I mean, you got lost in both. But then when it leads up to it, they got a certain tower. But that, they don't want to get the money. They'll hire like, oh, this is this, and they don't want to be small.
So they can't get their basement.
Yeah, that guy was.
Takes them too long to get there. They're trying to wait.
So that's why they call it the fire.
Yeah, it's a standard.
Now, it's like 9:50, and we've come out of executive session. Item D, there is no action. So we'll move on to the contested cases. We'll start off with G1, Adrian Brown. So Trevor, if you can come up. Real quickly, if you are have a case before us and you're here to speak on the contested cases, just keep in mind that we can only take into before us those things that were brought before a judge, unless it's a default case. But I think these are all contested cases. So if you presented in a court case, feel free to talk about it. If it was not presented in a court case before the SOA judge, then we're not allowed to hear it in this particular hearing. So just kind of keep that in mind. If for some reason I accidentally skip you, please raise your hand and say I'm here or whatever, but I'll try to call you up as we go through. We do have several people that are present today. So, and I will also make a call out in to see if someone is here and failed to fill out a form. So first one is Adrian Brown. Is Mr. Brown or Representative Mr. Brown present? Trevor, go right ahead.
Good morning, Commissioners. My name is Trevor Phelan, and I represented TDLR at the SOA hearing against Adrian Brown. Monica Ledford of Cypress, Texas, hired Adrian Brown to install a new Train air conditioning system in the summer of 2012. Ms. Ledford paid $6,000 up front for this installation.
This is Deborah.
Mr. Brown sent 2 men to Ledford's home to install a ream system instead of the Train system which was promised. The system immediately leaked refrigerant and condensate, damaging Ledford's house and yard. Over the course of a year, Mr. Brown himself and other men sent by Mr. Brown attempted and failed to make Ms. Ledford's system work properly. After a series of broken promises from Mr. Brown to work on the system in the summer of 2013, Ms. Ledford consulted another AC company and found out that A, Mr. Brown was unlicensed despite his documented promises to Ms. Ledford that he was licensed, and B, her system had significant installation problems that would cost additional thousands of dollars to fix. The ALJ considered the range of penalties for unlicensed ACR contracting, which in this case was $1,000 to $5,000. The ALJ specifically found that this violation was serious and that when the problems with the system were discovered, Mr. Brown did not try to make things right by referring Ms. Ledford to a licensed professional, but instead exacerbated the problems by attempting to handle them himself. The ALJ found that our recommended penalty of $4,000 was a reasonable punishment for Mr. Brown. Please note that this ordeal has already cost Ms. Ledford $6,000 and that doesn't count the additional cost of having someone else install the system correctly. I recommend that you adopt the PFD as written. Do you have any questions that I can answer?
Any questions for Mr. Thielen? Motion to be in order?
So move as recommended. That we adopt the PFD as recommended.
There is
some
I think there's some, go ahead. Amendments.
I was going to say, before we do a second, if the motion, I'll go ahead and make a second, but if the motion maker can cite the amendments to the conclusion of law
Right here.
as part of the motion.
Do you want to withdraw your motion and start over again?
Yes.
Okay,
Well, I don't
so the
have-
motion's been withdrawn.
Okay, well.
New
Do you want me
motion
to
to be
make
in
the
order?
motion?
If you like to, yes,
Okay.
once you do that.
I'd like to amend the motion to conclusion of law number 1 to correctly cite the applicable law under Occupations Code Chapter 51 and 1302, and to amend conclusions of law number 6 to correctly cite the applicable law in the Occupations Code Chapter 1302. And then to adopt as recommended otherwise.
I'll second that.
We have a motion second. All in favor signify by saying aye.
Aye.
Those opposed, motion carries. Item 2, David Benitez. Mr. Rennick.
Commissioners, Robert Rennick from the Enforcement Division. This applicant seeks a registered air conditioning and refrigeration technician license. In 1994, he was convicted by a jury of sexual assault. He was also convicted of burglary of a habitation with intent to commit sexual assault. The jury sentenced the applicant to 20 years in prison in each case, even though the applicant had no prior criminal history. The crimes were committed during one incident. The victim was a 59-year-old female. The applicant was born in 1965. He was approximately 27 years old when he committed the crimes. He was released from prison in April of 2014, just 2 months prior to applying for this license. The ALJ recommends that the Commission deny the application because of the severity of the crimes, because of the short period of time that has passed since the applicant's release from prison, and because of insufficient evidence of rehabilitation. The Department recommends that the Commission adopt the PFD. I'll take any questions you might have.
Is anyone here for Mr. Benitez or Mr. Benitez himself? Commissioners, any questions for Mr. Rennick? A motion to be in order?
I'll make the motion to deny the application and adopt the PFD as presented.
There's some amendments on that one too.
Second that motion.
We have a motion and a second.
There's some corrections on that one.
There's
There
a
is?
correction.
I didn't see that.
Yeah, there's reference to,
No.
Yes, you are.
Mr. Chairman, this is Brad Bowman, General Counsel.
Yes, sir.
I think there was a kind of a stray reference to the wrong
If you're
statute.
referring
It's-
to
it's
1305 to 1302, which is, in my opinion, editorial, but I will go ahead and add that to my motion. I mean, the 1305, that's referenced to 1302.
So your amended motion, would you accept a second to that, Mr. Commissioner Butler?
Yes, sir, I will.
So we all have amended motion in reference to 1305, which should be amended to read 1302 in the PFD. Any further discussion? All in favor signify by saying aye.
Aye.
Those opposed, motion carries. Item 3, Stefan Reese. Mr. Sharp.
Good morning, Commissioners, Chairman. The applicant in this case is Mr. Staffen J. Reese III. By the way, my name is Ken Sharp, for the record. I work in the Enforcement Division. The applicant in this case is Mr. Staffen J. Reese III. I'm not sure if he is here. I didn't see his name on the registry. On June the 16th of 2014, Mr. Reese applied for a registered air conditioning and refrigeration technician license. The department proposed the denial of his application because of his criminal history. Based on that criminal history, the administrative law judge recommends the denial of his application. In 2005, the applicant was convicted of possession of cocaine and sentenced to 9 months confinement in the Harris County Jail. He was 18 years old when he committed that offense. In 2006, the applicant was convicted of unauthorized use of a motor vehicle and sentenced to 6 months confinement in a state jail facility. Later in 2006, the applicant was convicted of criminal trespass and sentenced to 90 days in the Harris County Jail. In May 2007, the applicant was convicted of possession of marijuana and sentenced to 45 days in the Harris County Jail. In July 2007, the applicant was convicted of theft from the person and sentenced to 8 months confinement in state jail. In that offense, during the course of stealing property from the victim, the applicant struck the victim with his hand to facilitate the theft. In 2008, the applicant was convicted of misdemeanor theft and sentenced to 30 days in the Harris County Jail. In that case, the applicant stole a DVD player. In 2012, the applicant was convicted of theft, habitual. He was sentenced to 1 year of confinement in state jail. That offense occurred when he was 25 years old. The applicant was released from prison in September 2013 and applied for the license 9 months later. Because of the serious nature and a number of crimes, the ALJ could not find at this time that the applicant has the necessary honesty, trustworthiness, and integrity required for a license. The ALJ noted there simply has not been enough time since the applicant has been out of prison to be able to determine whether he actually has turned his life around and is fit for licensure. The ALJ recommends the denial of Mr. Reese's application. The department recommends the commission adopt the ALJ's proposal for decision. Thank you.
Is Mr. Reese or anyone representing Mr. Reese present? Any questions for Mr. Sharp? A motion to be in order?
Move to adopt as presented.
Second.
We have a motion and a second to adopt the PFD as presented. All in favor signify by saying aye. Aye. Those opposed, motion carries. G4, Boyd Thompson, Mr. Sharp.
Thank you, Mr. Chairman. And I understood that there was a communication from Mr. Thompson that he might not be able to appear, but he wanted to.
Yeah, this is Brad Bowman, General Counsel. That's correct.
Oh, I do.
He
I've got it here.
called. Apparently, he broke down on the side of the road on the way here, is what he said, and I think he talked to the staff in our office, and so that's kind of the. Apparently, he was not going to be able to make it, was our understanding, and I think we were going to try to get a hold of him again, but maybe we're. Okay, so that's all we know at this point, is he called and said he broke down on the side of the road and was apparently not going to be able to make it.
Mr. Chairman,
Yes, sir.
it might be good to pass on this until the end, find out whether he's going to be able to make it, and then you can just make a determination whether to hear it or not.
Yeah, why don't we do that? Why don't we just hold off on this item right now and put it towards the end, and
I think
we'll
I
see
can
if he shows.
I can
If
vouch
you're
for
okay
the
with that.
condition of his car because he had car troubles that prevented him from making it to the hearing on time also, so.
So he's got the same car, obviously.
Apparently so.
Okay. Well, let's hold off on this for right now, and then we'll get back at it. G5, is it Brundage? And I believe Mr. Brundage is here. Is this on? Okay. If you want to come on up, you can come up and sit in this other table. Mr. Rennick.
Yes, Commissioners, Robert Rennick again. The department seeks to revoke the respondent's Class A barber license, which was issued in 2012. On March 27th of 2013, the respondent pled guilty to robbery. He was placed on deferred adjudication for 6 years. He committed the crime in January of 2013, just 7 months after getting his barber license. He and 2 other men answered a Craigslist ad placed by the victim who was trying to buy an iPad. The respondent drove the other 2 men to meet the buyer at a Best Buy parking lot. One of the men with the respondent demanded $150 from the victim, while the other man who was with the respondent pointed a gun at the victim. The 3 men took $120 from the victim, as well as an iPad the victim had in his car. At the hearing, the respondent mentioned that he also had 3 deferred adjudications in 2007. They were for the crimes of theft, theft of a firearm, and burglary of a habitation. The respondent was 26 years old when he committed the robbery. On his renewal application, he answered no to the criminal history question. He testified that he did that because his probation officer told him that deferred adjudication is not a conviction. The ALJ then pointed out to the respondent, and this is the ALJ questioning him himself, not me. The ALJ pointed out that the criminal history question simply asked whether he pled guilty or no contest to any felony or misdemeanor. And the ALJ asked the respondent why he answered no when he had pled guilty or no contest. And the respondent had no response to the ALJ's question. The ALJ recommends that the commission revoke the respondent's license. He cited the seriousness of the crime as well as the respondent's untruthful answer to the criminal history question. The department recommends that the commission adopt the PFD and revoke the license.
Any questions for Mr. Rennick? I do have a public comment form from Arthur Bundridge Jr. I guess that would be you. Okay. So if you don't mind, again, state your name for the record, but also, as I mentioned earlier, the only thing we can consider here was which was brought before the ALJ in the SOA hearing. Any new testimony and new evidence is not to, we cannot accept at this particular time. So if you don't mind, just state your name.
Arthur Bundridge.
Go ahead.
Basically, all I got to say is...
Go ahead and move the mic closer to you if you don't mind.
All I have to say is due to my, like, conditions of asthma, this is the only thing I have, like, going for myself, and I know that I've messed up in the past, but I'm trying to get back on the right foot.
Any questions for Mr. Brundage?
Can I get a comment also?
No, sir, you did not fill out a form. I need you to fill out a form if you did.
Oh, okay.
Which is fine. If you want to, just grab one and fill it out and just hand it to Ms. Mahon after we finish here.
Okay.
But yes, go and state your name for the record.
My name is Arthur Brundage Sr. In response to some of the comment that Mr. Riddick made, he did not, some of the things was not necessarily correct. But anyway, the reason why my son is here today is that the fact that he has severe asthma. And revoking his license, that's the only means that he have being employed. And without that, you know, he's going to have to basically be...
Was that presented in the...
Yes, it was.
Okay.
It was. And that's the only thing that he have that he can do. He has a learning disability, which was presented, and he didn't bother to bring that up. And also the severe case of asthma, which prevent him from doing any of the other type of work. So basically, that's all I want to say.
Any questions for Mr.
Look, yeah,
Brundage Senior or Mr. Brundage?
The only, I think the, you know, the condition, you know, health condition. I guess the other question I would have is really regarding, I don't know that answers it doesn't answer the question for me in terms of your behavior, in terms of what happened in terms of you being involved in the crime. Doesn't explain your health, and doesn't, to me, that doesn't seem to answer the question or give us any information. Why are you fit to be a barber?
Basically...
Can I assist him? Because one of the things...
I'd actually rather hear it from him.
Okay.
You'd rather, yeah.
Right.
Tell him.
Can you repeat the question again?
Why is your behavior fit to be a barber? Why are you fit to operate with a license, with a state license, with your to be a barber?
Mr. Brundage, grab the mic and put it closer to you.
Basically, I grew up cutting hair. That's something I like doing. And after I got in trouble, I decided to try to turn my life around and do something that I can actually love doing. And so that's why I chose to be a barber.
Well, if I could ask you one question. The crime in 2013, I believe, was committed after you became a barber. Is that accurate?
7 months after he became a barber.
And did you understand at the time that if you committed this crime, that would be grounds for revoking your license immediately?
No, ma'am.
I have a question for Mr. Rennick. The deferred adjudication issues, am I correct in remembering that on our application we explained that deferred adjudication is also considered a conviction that you're supposed to acknowledge?
The application doesn't explain that. In this case, it's an application that doesn't specifically ask whether he's been on deferred. It asks him whether he pled guilty or no contest. And he answered no, but in connection with the deferred, he pled guilty. So the ALJ considered him to be untruthful on that issue. But it doesn't specifically address deferred adjudications. Most of our license applications now do. They ask, have you ever been convicted of or placed on deferred adjudication for any felony or misdemeanor? This one just asked, have you ever been convicted of a felony or misdemeanor or pled guilty or no contest?
Now, and I understand that that does cover our requirements for putting applicants on notice, but I would encourage all of our applications under compliance to include that, because, you know, people can get misleading information from their attorneys and probation officers if we don't make it really clear. Because I know it's provided by statute, but it's very unique.
Right, we've been moving in that direction.
With the commission's permission, could I respond to one point
Yes.
made by the respondent?
Go ahead.
I think it was the respondent's father who was speaking, and I think the respondent, to some extent, were saying that the only thing he can do is work as a barber because of asthma. Well, the respondent submitted a recommendation letter himself from Charles Wallace Construction and Landscape, and Mr. Wallace said, this letter is to verify, this is in evidence, this letter is to verify Arthur Brundage's temporary employment with my company and a character reference. Arthur has been working on a temporary basis with my company for over 5 years. He is and this was submitted on January 12th, 2015. He said, he is a very dependable and hard worker. It's my pleasure to provide this character letter for Arthur.
What do you do for him in the landscaping business?
And what that is I basically go out with him and I'll ride with him in the truck when he does need me. And at the time being, it's too hot for me to be outside because of my asthma. So I haven't been with him, but I go with him and pick up the supplies with him. But as of like right now, I don't really.
So you just go and pick up supplies all you do?
Yes.
You don't do anything else with him?
No, because he does like retaining walls and stuff that you actually have to be in the heat to actually do.
So all you do is pick up supplies?
Yeah, I help him pick up supplies.
And no other work?
Not really.
And I'd like to make one other comment. It also was stated on the record. My wife filled out the application for him, and she was the one that responded because of his disability, and basically he signed it. And I understand that by signing it, you admit that you understand the question and the comment, but in his case, the only thing he did was signed it, and she was the one that was misled by the question on the application.
I think it was pretty, I don't know how you can get misled when it says, have you ever been convicted of or pled guilty or nolo contendere or no contest to any misdemeanor or felony other than a minor traffic violation that you have previously reported to the department? I don't know how you get misled by that question.
And the fact that we consulted with his probation officer, and she mentioned the fact that deferred adjudication. So we were going under that presumption, and also the fact that she really didn't read the question in detail.
But he is still responsible for that?
Yes, I understand that. And that also was stated during the hearing.
And I guess it still goes back to the question that was asked previously was, you committed this crime 7 months after you got your license. And at never, any point in time, you didn't think that would be a problem?
Well, the way the situation went down when it happened, it wasn't supposed to occur like that, but that's the way the outcome came out of it. And now I'm dealing with my consequences, and I'm trying to turn around.
And I applaud you for that. But we still have an issue here about your license.
Okay,
Mr.
I'm
Moses?
ready to make a motion. I move that we adopt the PFD as recommended.
You need an amendment.
Do we, I don't know, and the Office of General Counsel, is that right?
Mhm.
Conclusions of law 5 and, yeah.
7.
And 7.
So we have a motion
Okay.
to amend the PFD based on, what is it?
I thought it was. This is item, is it, where, item 5?
Yes, you're right. It's number 5.
Yeah. Okay. Adopt the PFD and conclusions of law 5.
Oh, it should be amended. Conclusion of law number 5 should be amended to actually cite and interpret Occupations Code 51-356, so.
So
I think
recommended.
That's your motion?
Yes.
Commissioner Moses, okay. We have a motion.
Mr. Commissioner, Mr. Chairman, may I say something to Mr. Brundage?
Yes.
Mr. Brundage, You've been given a lot in your life. You have a father who's willing to stand up there next to you and make excuses for you. Obviously, he loves you. You've got a great example there, a good role model. And for whatever reason, you've taken all that you've been given, this license that you've been given as well by the state, and you've turned your back on it. And I don't understand it. I don't understand. So many people would love to have what you have there. A license to earn money, and a man who loves you sitting there next to you, backing you up. And you take it for granted. And now I don't know what's going to happen here. My guess is you're going to lose your license, and you're going to be angry at us. When you need to look in the mirror and ask yourself, why, when you've been given so much, would you throw it all away? You've got a chance to make something of your life, and you need to do it. Stop wasting it. You understand? You've had two offenses now involving handguns. You understand where your life's going, right? Okay. And you brought it all on yourself. That's all I have, Mr. Chairman.
We have a motion on the floor. I think the motion is to adopt the PFD and amend conclusions of law 5 to reflect inside the proper occupations code 51356. Is that right?
Yes.
Okay.
Yes, okay.
We have a motion.
And then also, I guess, if we adopt the PFD and accept the recommendation as I guess it would include comments from the general counsel, right? Correct, we do that. And that's what we're doing,
Right,
okay?
right.
In this Brad Bowman, it's just a technical correction.
It's just a
correction
technical
to
one.
Okay.
how the law was characterized by the judge in terms
Okay.
of
Yes,
the
sir. Okay.
Chapter
Yes, sir.
51 provision. It doesn't,
We have a motion
doesn't
and a
affect the
second.
outcome.
No, we have a
No, we
motion
don't
on the
have a
floor.
second.
I'm looking for a second.
Second.
And a second. Commissioner Shaw.
I'm struggling with this case, and I've struggled with this case after I'd read it, and I've probably read it a couple of times. There's some obvious reasons why I will vote for the motion. One of them being is that I think the license was issued and then the crime was created 7 months later. And I think that's the basis of my motion, or the vote of my motion. So I just want to make that part of the record.
Are there any other questions for Mr. Brundridge or Mr. Rennick? So,
Just one comment.
Yes, sir.
I'd like to thank Mr. Butler for his comment, and also we appreciate, his comment, and Arthur he's gonna take that into consideration. We realize that he messed up, and, we just have to accept your position and hope that we don't have to be awarded some compensation from the state for his mistake, because that's the only alternative that he have.
appreciate it. Thank you. We have motion and a second. All in favor signify by saying aye.
Aye.
Those opposed? Motion carries. Mr. Brundage, just so you know, this doesn't prohibit you from obtaining a license in the future. I invite you to go ahead and try to apply down the road sometime. I can't give you a specific time, but just work with the staff when you begin to start doing that. And just remember that the answer is yes when you ask that question again. All right? Thank you, appreciate it. And Mr. Brundage, if you have your form, thank you, sir, appreciate it. Thank you. Move on to item G6. Roderick Keith Whitley. Is Mr. Whitley or anyone representing Mr. Whitley? Mr. Sharp.
It is. It is.
Thank you, Mr. Chairman.
It's sad.
Ken Sharp, Enforcement Division again. The applicant in this case is Mr. Roderick Keith Whitley, who has applied for a barber license. He has a significant criminal history beginning in 1992 and extending into May of 2014, consisting of 1 deferred adjudication and 18 convictions, most being offenses that involve drugs that fall under the Commission's guidelines. He was released from his most recent period of incarceration in or about June of 2014. He applied for a Class A barber license on October 27, 2014, only 4 months after his release. Based on Mr. Whitley's criminal history and the brief period of time he had been out of jail since his most recent conviction, the administrative law judge recommends the denial of his application. And since this applicant has 18 different convictions and the one relevant deferred adjudication with the Commission's consent, I'll try to briefly summarize them, although I'll certainly provide additional details on the Commission's request. The applicant's first court action was a deferred adjudication for delivery of a controlled substance, cocaine, in 1992 when he was 19 years old. He has 2 convictions for delivery of a controlled substance, the most recent being in 2014. He has 6 convictions for delivery of a simulated controlled substance. 3 of his convictions were for possession of controlled substance. 1 was for possession of marijuana. He has 3 convictions for assault offenses, the most recent being in 2014. He has 1 conviction for theft, 1 for criminal trespass, and 1 for violation of a protective order. As indicated above, 6 of the applicant's convictions involved the delivery of a simulated controlled substance, and the evidence at the hearing revealed that simulated controlled substances can be even more dangerous than the actual substances the seller claims them to be, and that's because manufacturers of simulated controlled substances often use toxic ingredients in an attempt to produce an effect similar to the actual drug or simply as fillers. In her analysis, the ALJ noted the applicant's criminal record spans almost his entire adult life. At the time of the hearing, the applicant had been out of jail for less than a year, and while he has begun recovery efforts, not enough time has elapsed for him to establish a consistent record of compliance with the law, especially in light of his extensive criminal history, with 5 of his convictions having occurred within the past 5 years, or within 5 years prior to his application. The ALJ concluded that at this time the applicant has not shown that he is sufficiently rehabilitated and fit for licensure as a Class A barber, and the ALJ recommended the denial of Mr. Whitley's application. The Department recommends you adopt the PFD as written. Thank you.
Any questions for Mr. Sharp? Motion be in order.
Mr. Chairman, I deny the application and adopt the PFD.
Second.
We have a motion and a second. All in favor signify by saying aye.
Aye.
Aye. Those opposed, motion carries. G7, Brian Hook, I believe, is that correct?
I think he pronounced it Hauk at the hearing, yes, sir.
Is Mr. Houck available, or anyone representing Mr. Houck? Mr. Sharp, proceed.
On June 11, 2014, Mr. Brian S. Hauk applied for an apprentice electrician license. The Department seeks to deny that license application based on the applicant's criminal history. After considering the applicant's extensive and serious criminal history, mostly involving theft and burglary, and the relatively short period of time he's been out of prison, the administrative law judge recommended the denial of Mr. Hauk's license application. The history of the applicant's criminal convictions is somewhat extensive, so I'll provide it in a summary form, if I may. In 1994, there was a deferred adjudication for theft. In 1995, there was a deferred adjudication for possession of marijuana that was revoked in 1997, and in which the court found him guilty and sentenced him to 20 days in jail. In 2000, the applicant had convictions for theft and criminal trespass of a habitation. In 2003, the applicant was placed on community supervision for 3 years for burglary of a habitation. In 2004, the court revoked that community supervision and sentenced him to prison. In 2004, he was convicted for theft after having been previously convicted 2 times. In 2004, he was also convicted for unauthorized use of a motor vehicle. In 2006, he was convicted of felony theft of property and having been previously convicted of theft 2 times. In 2009, he was convicted of burglary of a vehicle. Also in 2009, he was convicted of criminal trespass to a building with a suspended sentence that was later revoked that same year, resulting in a jail sentence. In 2011, the applicant was convicted of burglary of a habitation and sentenced to 5 years in prison. In 2013, the applicant was again convicted of the offense of burglary of habitation and sentenced to 10 years in prison. He was released from prison on November 7th of 2013 and is scheduled to remain on parole until 2021. And that was a lot. So to summarize, he had convictions for unauthorized use of a motor vehicle, burglary of a motor vehicle, criminal trespass to a building, criminal trespass to a habitation, 4 theft convictions, 3 convictions for burglary of a habitation, 2 of those being the most recent of his offenses. The ALJ found that while the applicant is taking the right steps toward rehabilitation, not enough time has passed to confidently conclude he is currently fit for licensure. And in light of his extensive and serious criminal history, most involving theft and burglary, and the relatively short period of time he's been out of prison, the applicant did not meet his burden to show that he now has the honesty, trustworthiness, and integrity required for issuance of a license. The administrative law judge issued a proposal for decision that recommended the denial of Mr. Houck's license application, and the department recommends that you adopt the PFD as written. Thank you.
Any questions for Mr. Sharp? Motion to be in order?
Move that the PFD be adopted as recommended.
We have a motion
Second.
and a second. All in favor signify by saying aye.
Aye.
Those opposed, motion carries. G8, Frederick Martin. I believe you're here, Mr. Martin. Go ahead and have a seat up here, sir. Mr. Rennick.
Commissioners, the department seeks to revoke the respondent's journeyman electrician license. In 1992, he was convicted of unauthorized use of a motor vehicle and sentenced to 6 years in prison. The sentence was suspended, and the respondent was placed on community supervision for 6 years. Then, in 1996, his community supervision was revoked, and he was sentenced to 3 years in prison as a result of that revocation. After that, in April of 2005, the respondent was convicted of theft and sentenced to 4 days in the Harris County Jail. 8 months after that theft conviction, in December of 2005, the department took a chance on the respondent and issued him a journeyman electrician license. Then, in 2010, the respondent was convicted of possession of a controlled substance and sentenced to 3 days in jail. Finally, on March 4th of 2014, the respondent pled guilty to another theft. For this one, the court placed him on deferred adjudication, community supervision for a period of 1 year. The crime occurred on June 23rd of 2013 when the respondent stole some spools of copper wire from a job site. The respondent was born in 1973. He was approximately 19 years old when he committed the unauthorized use of a motor vehicle in 1992, and he was approximately 40 years old when he committed the theft in 2013. When the respondent submitted his renewal application, he answered no to the criminal history question, which asked if he had been placed on deferred adjudication since his most recent license was issued. At the hearing, the respondent testified that he answered no because he thought the deferred adjudication would not show up on his criminal history. The ALJ recommends that the commission revoke the license because of his criminal history, because he recently stole on the job, and because he falsified his renewal application. The department recommends that the commission adopt the PFD and take any questions.
Any questions for Mr. Rennick? Mr. Martin.
Yes, sir.
If you don't mind, state your name for the record, and again, as I mentioned earlier, you can only bring forth those things that were brought forth in the SOA hearing.
Yes, sir. My name is Frederick Martin.
Go ahead, sir.
Okay, on the 2005 offense, when the council, when they took a chance on giving me my license, it was already under investigation. I was called, and it was recorded and everything, and it was deemed at the time that my offense or what have you, especially after he found out the ramifications behind the offense, which the prosecutor did not have, which I found strange not to have about the case, they had deemed that it was not an offense that would keep me from getting my journeyman's license, so I was therefore given my journeyman's license. On the offense with the slight drug charge, that was my wife's medication that I had in my possession. Me and my wife were going in through something at the time, and I had her medications in my car. And when we were pulled over on a minor little traffic stop, that's what they found, and I couldn't get her to come in to give me any help on that situation due to the matter of what we were going through at the time. Okay, in 2013, I was a foreman over a job, and I was working for Power Design. Power Design is an outsourced company from Florida, so therefore I was just there as supervisory. I was looking over some of the people that they had working. The people that they had working for them some of them were illegal and some of them didn't have licenses. So therefore, we had already had a problem with wire coming up missing. So the whole crew was on the lookout. Well, I move around a lot of wire and I move a lot of the stuff from place to place, but therefore I'm not responsible for pulling wire, which means I only take it to one spot with a rolling cart and I leave it. I don't lock it. I didn't have anything to do with it. So we were already having an investigation about that. Okay, I showed up on a Sunday when I was supposed to show up on a Saturday. I went out of town with a girlfriend of mine. Well, I came back in my Bermuda shorts and fresh from my little slight vacation, and I went up to the job. I should have really went Saturday when I was supposed to. Well, when I went inside, I had already got a call Friday to bring some jet line from the job site to the other job site, and I'm supposed to show up Wednesday. Okay, our jet line was broken out of the box. It was put onto a spool. So when I came out with the spool on my shoulder, it was blue and white. I mean, we all know the color of jet line. So she said that there was some number 10 blue and some number green, some number 10 green missing. Well, they stated that she was 50 yards away. So how could my thing is, how could a janitor know what size the wire was or what she saw? Well, it was just my bucket. It was just my handy bucket that I always keep my tools in. You can get it from Home Depot to put your tools around. And it was the spool of jet line. So that's all that I took out of there. Okay. I was going through a divorce, and I was trying to get to my kids. So the reason that me and the prosecutor came up with it to take the adjudication is that, hey, it wouldn't show up on your life. I told her the ramifications of everything I was trying to go through. And it didn't look good that I'm trying to go get the custody of my kids at the same time that I'm going through a case. And I'm trying to get a job to get into a level 1 security facility. Well, after I took the adjudication, all that went through. And I asked her a question about my license. And she said, oh, it won't affect nothing. By the time anything goes on, your case will be through and everything will be gravy. Everything will be great. So that's the reason why I answered no, because it didn't specify if it said adjudication at the time of my renewal. And yes, I have had a few things in the past, but I've never did anything that was constituted towards my job. I've held my electrical license up to the finest of visibility. I've worked for some of the best electricians I know. I worked for John Pollock, I worked for Clark Reynolds, and I worked for Richard Battle. And I've always been upstanding. I've never had a complaint. I've never had anything to where I've been stealing. I've always been put in the charge of the highest level of my job. And I've never had this complaint before. And it was already stated, which the district attorney didn't have either, that Paul had already did an inventory and said that there was no number 10 missing from the job site, only number 6 green and number 6 yellow, which we know at 2,500 feet, it would be highly incredible for me to pack that out of that building without a forklift.
Any questions for Mr. Martin? Mr. Rennick.
I just want to say that the probable cause affidavit for the theft of the wire was introduced and is in evidence. He loaded the wire into a pickup truck. Custodian goes up to him and says, "What are you doing?" And he says he's loading the wire. He says, "Can I see some identification?" The respondent jumps in his truck and takes off.
I have a word. The lady that came up to me.
Then he pled guilty to the crime. He could have made this entire explanation at a trial if he believes he was not guilty, but he pled guilty to this crime, and the ALJ believes the commission should consider it a conviction for Chapter 53 purposes.
The lady that came up to me, it wasn't a man, it was a female. The lady that came, she did not actually come up to me. I was coming out, my truck was parked. It's also supposed to say that they had pictures of everything, which all this fell through. My lawyer at the time that I was trying to get to support me had already taken like $3,000 from me. And at the end of right in the middle of the trial before we go in, he's asking for more money. And then he decides to pull off my case. So I got this probation with a court-appointed lawyer that I paid $200. I paid $3,000 to a man who screwed me. Then I got $200 for this. My house was about to get foreclosed. I was going through the trial with my kids. I had to do something, especially when they said that it was not going to show up. And I took on these responsibilities, and I carried out all those things. I have my children. I stopped the foreclosure of my home. But at this point, if my license is revoked, I will have no other way to take care of my children, and everything else in my life is in limbo. for a minor mistake that somebody else made. The person that they were supposed to have for evidence, he couldn't come to the courtroom because he was illegal. Well, by that time, it was just so much going on.
I don't know that any of this was in the record. But
Did you
This-
submit this at the
he's
SO
saying
hearing?
right now.
At the SO hearing? What you're talking about right now?
I didn't get a chance to get any of
Okay,
that.
we can't hear you.
Okay, I'm sorry.
So there is an affidavit of your guilty plea? Is
There-
I had to plead no
There was
contest.
a plea of guilty on the
Plead
deferred
guilty.
adjudication
I'm sorry, an
order.
affidavit of an individual, a witness.
And then there's an affidavit of the evidence the police had when they arrested him.
Okay.
And none of that, I didn't see any of that at the hearing. We didn't get none of that submitted. And what they had, that affidavit that they used since he spoke on it, came off Leads Online where anybody can go on there and put that in.
But it was submitted at the SO hearing?
Yeah, and yes, and
Is
the
that
car
correct?
the car that they said that I brought it in hasn't been wasn't registered in my name in 3 years.
Okay.
I hadn't had
But-
that car from
Right.
2010.
Okay.
This is
But
2000.
if this evidence was brought forth at the SOA hearing, so you listened to it at the SOA hearing?
Yes, and I had no idea that some of the information that he had, I could have said I didn't want in there, because I'm not a lawyer. I didn't know.
Right. Any questions for Mr. Martin?
Mr. Martin? Yes, Mr. Chairman.
Yes.
Are you currently working right now?
Yes, I am.
And how long have you been an electrician?
I've been an electrician since 1997.
1997, okay.
He's been licensed by us since 2005.
Mr. Shaw?
So I have a couple of questions, this probably have no merit to the decision I think that the commission makes, but I think for myself, it would help me to understand a little bit better about the progress that you've made. Being a journeyman electrician, have you pursued your master electrician license?
And that's where I'm about to head right now. But I was about to submit that and take my master's electrician's license, but I can't now because of the ramifications of this case.
Thank you, sir.
And
Mr. Butler?
what is the maximum that we have probated licenses in the past? Do we have an idea what?
Well, I think you can just do it to the next time it's up for renewal, right?
Yeah, I think we've gone a year. I think next time renewal,
Yeah.
I think it varies.
When is your license up, Mr. Martin, do you know?
Right now, it will be in about 2 months, will be at renewal status, because I just tried, well, no, I think they sent me the letter and I tried to renew it again, just now. And they said there would not be anything they could do until the case is finished. So that would put me already almost out of statute, and then I'd have to, wait. But I add from the time that I accepted the probation till now, I think would be, maybe not to the council, would be a good indication of how I've been carrying myself here lately. Because, I mean, that's all I've been doing is working, and that's how I had it at first. And
Mr. Martin,
Mhm.
I found it hard to follow your explanation. It sounds like you're shucking and jiving.
Oh.
But you've had your electrician's license for 10 years. I'm willing to take a chance on you. I can only speak for myself. But I'd be willing to probate Mr. Martin's license. If he does get it, can somebody answer how long he'll have it?
It's Brad Bowman, General Counsel. It's a 1-year license, but in terms of how long the probation period, that would be up to the commission to decide how long. I think technically we'd be suspending the license and then probating that for some period of time.
Again, I'd be willing. I'm an optimist. You're here. That's got to stand for something. I'd be willing to probate your license for a couple of years. I'd like to make a motion that we do that.
Can I make a comment before you
Sure,
complete your
absolutely,
motion?
absolutely.
You may want to correct the technical issues in the motion before you add on the probated suggestion, just so we can do it all at one shot.
What are you specifically referring to?
I
Deborah? I'm
think there
sorry.
needs to be just a technical,
The ALJ's
deleting
findings?
conclusions of law number 10, modifying conclusions of law number 11,
Okay.
to remove the reference to the wrong 51
Statute.
point, right, renumbering the conclusions, and if that makes, if
Sure.
that's my
That
understanding,
makes
is the
sense.
recommendation of the technical part, and then you can do the meat of your motion.
Okay. So Brad, in my motion, should I revoke his license and then probate it? Is that what you were saying?
I think the commission has done, typically, it would be a suspension and then a probating the suspension. And then whatever period of time you want to set for that, and then the conditions that the respondent comply with with the statutes and rules of the department during that period of time.
And so if we're not accepting the ALJ's recommendation, do I still need to, Deborah, is it your thought that we still have to make the technical modifications?
Well, correct, because then if he violates his.
Okay.
Then we want it all.
Great, thank you for that.
Also, let me ask a question.
Yes,
I
go
guess
ahead.
you're Tom, well, can we, I guess, Brad, can we adopt the PFD and then probate his license? Can we adopt the PFD and then do a probation? Could we adopt the PFD and then probate the revoke?
It would be, you would be
Amending the
modifying the
PFD.
PFD, and I think it's really the conclusions of law 10 through 13.
Right.
They're the technical issues that Commissioner Yurko mentioned, but you'd be adopting the PFD with modifying those conclusions of law to suspend the license and probate it.
I think we're saying the same thing.
I think okay. We're saying.
Just two different
Okay.
ways we're coming at it.
All right.
And Mr. Chairman, the difference between suspension and revocation, if a license is revoked, it's downtime for a year. If the license is suspended for 6 months and then probated, if he violates that, he would be out for 6 months. If it was revoked and probated, if he violates, it would be out for a year. So depending on how you want to...
The severity of it.
Yeah, what incentives you want to include in the order in order to maintain the proper behavior.
Bill, when you say out, you're saying he's not able to use the license for 6 months or a year?
On a revocation, you're not able to
Right.
apply for a year after the revocation. A suspension, you can set that time period.
Okay.
So,
Okay.
That's assuming
Yeah.
if he failed the probation.
Okay. So let me get this straight, Brad. I'm going to make a motion that we suspend the license, address the technical.
And then the revocation option also that you have that Bill mentioned.
right, in a suspension, you have to give a time period. Suspend for 6 months, 9 months, 12 months,
The revocation
a
is
year.
1 year,
and then probate it.
but the revocation will be 1 year.
That's correct.
Right, well, and the revocation is indefinite, it's just they can come back after
Right.
1 year and reapply. That doesn't guarantee they get the license in a year, but.
Right.
Commissioner Shaw, go ahead.
If I may ask the question of Bill, maybe, in which scenario can the applicant continue to perform work?
And when you probate it, the applicant can continue to work. That probation,
That's right.
probation allows him to continue as if you didn't have the sanction against him.
But any violation of the probation under revocation means that the license is revoked for 1 year.
That would be
From the
correct.
time that there's a
If he
violation.
fails.
At least a year, yes.
Now, if you suspend it, any violation of the probation means it's only suspended on the time definite that you put in your motion.
And does it how onerous is it to the department that we do these sorts of things? The probation, does it matter to you if it's 1 year or 2 years? It's all the same, or?
No, because if there's a violation and it reports to us on the enforcement division, then, I mean, we're not doing a monitoring on a monthly basis.
And are we allowed to have a discussion as to how long
Sure.
we could do that?
It's a discussion with the commissioner somewhere. Do we have any other questions for Mr. Rennick or Mr. Martin? Okay.
Can I say one thing about the
Yes, sir.
suspension? If he really the only way we're going to proceed against him if you suspend this is if he either gets revoked on his deferred or he commits another crime. That's the way we get alerted to anything.
Sure.
It's not the, so,
Or if someone files a complaint.
Mhm.
if someone files a complaint,
Right.
but
I'm just saying, I mean,
Yeah.
there's another way that would get brought to.
that would be,
You don't
I'm
expect-
speaking of my subdivision.
Sure. I mean, we understand he's not
Yeah.
reporting to you like a probation
Yeah.
officer.
Right. You have a seat. Thank you. Discussion, Commissioners.
You ready?
1 year, 2 years?
I would say 1 year. When we probate it for 1 year, that's if anything happens within that 1 year. Is that right?
That's correct.
If we, yes.
Definitely.
I would say probate it for 1 year. That's my recommendation.
Okay, I would make a motion that we, to accept the ALJ, even though I don't want to revoke. That we not accept and then suspend?
I would adopt the PFD
As
and
modified.
modify it
Okay.
to,
I make a motion that we adopt the PFD as given to us by the ALJ with these modifications. Number one, that we delete the conclusion of law number 10. Number two, that we modify the conclusion of law number 11 to remove reference to 51.4012. Renumber the conclusions of law and recommend revocation only and not denial, since it is not supposed to be considered as applicable law. Does that make sense?
and I'm sorry, that would,
I would leave off the
that
last
that
one.
was
The last
assuming
one?
that the
Leave off number
decision
four.
would be to revoke
I'm so sorry.
the
Sorry,
the
just leave off number
license.
four.
I apologize for that.
No, that's okay, that's okay. And I recommend that we suspend his license for a year.
And to
Probate.
Probate
And to
it
probate.
Probated.
up there.
Do we have a
Okay.
second?
Second.
So we have a motion second to suspend the license and probate for 1 year. And of course, including the technical changes that have been included in that, but not included the fourth item.
Minus the fourth item.
Right,
that-
which you did mention, but it's now being pulled back, so.
I was just trying to see if y'all were on your toes.
Commissioner Shaw.
Yeah, this is another one of those that I've struggled with, and I probably will not be in favor of the motion for obvious reasons. I think, as our attorney has probably pointed out, there have been many instances, and there is no assurances that these instances would not continue, so I would be reluctant in supporting the motion.
Any further comment? I'm actually in line with Commissioner Shaw. I would be voting against this motion because I believe that based on the history that we have before us and the recent history there, I believe that there needs to be a time frame separated from this. So I would be in favor of revoking the license, but that's, again, my opinion. So any other comments? If not, we'll go ahead and vote. We have motion to second. All in favor signify by saying aye.
Aye.
Those opposed? No. So,
Sorry.
I apologize.
I was reading the note.
You're on your own.
Could you ask the motion again, please? I'm sorry.
You had a little brain burp.
Yay or nay?
Nay.
Okay. You want to go ahead and let's do roll call right quick, Kay? Sorry.
Mike Harris Mendez.
No.
Tom Butler.
Aye.
Luann Morgan.
Aye.
Fred Moses.
Aye.
Catherine Rodwald.
Aye.
Ravi Shaw.
Nay.
Deborah Yurko.
Aye.
Motion passes 5-2. So, Mr. Martin, you understand what we've done here, right? If you have any questions, feel free to get with staff, but basically, you have your license, but for 1 year, any violation of the probation means that your license, basically your license is suspended, but it's probated for 1 year. They will process it through. So, all right. So, we'll move on to item 9, Jared Diaz. Mr. Rennick.
Commissioners, the department seeks to deny the renewal of respondent's apprentice electrician license and revoke the license as well. He was originally licensed in 2004. In 1997, the respondent was convicted of deadly conduct and assault, sentenced to 180 days in the Travis County Jail. Since he has been licensed, the respondent has committed 4 crimes. In 2012, he was convicted of attempted criminal trespass and fined $199. That same year, he was convicted of resisting arrest and sentenced to 110 days in the Williamson County Jail. On March 14th of 2014, he was convicted of theft and sentenced to 40 days confinement in the Williamson County Jail. Finally, on April 17th of 2014, he was convicted of attempt to commit theft of a firearm and sentenced to 1 year confinement in the Travis County Jail. That sentence was suspended and the respondent was placed on community supervision for 2 years. The thefts in 2014 were, the thefts for which he was convicted in 2014 occurred in August and September of 2013. The applicant was born in 1970. He was approximately 27 when he committed his first 2 crimes. He was approximately 43 when he committed his last 2. On his renewal application, the respondent answered no to the criminal history question, even though he was convicted of 2 crimes just a few months prior to filing the application. The ALJ recommends that the Commission deny the renewal application and revoke the license because of recent directly related crimes, because he falsified his renewal application, and because there is insufficient evidence of rehabilitation. The Department recommends that the Commission adopt the PFD.
All right. Does anyone have any questions?
Madam Chair, I'll go ahead and make a motion to adopt the PFD as presented.
Hang on, is there anyone here representing Mr. Diaz, Jared Diaz? Okay, go ahead, Rob.
Motion stands. Adopt the PFD as presented.
Second that motion.
Okay, we have a motion and second. All in favor signify by saying aye.
Aye.
Anyone against? Okay, motion passes.
Item G10, Dakota Davis. Mr., I believe there's
Davidson.
someone here, if you don't mind, just come on up. Mr. Davidson, I'm sorry, Davidson. Mr. Rennick.
Commissioners, the Department seeks to deny the renewal of Respondent's apprentice electrician license and revoke it. He was originally licensed in 2012. On June 16th of 2014, the Respondent pled guilty to burglary of a habitation. The court placed the Respondent on deferred adjudication community supervision for a period of 6 years. The crime was committed on May 14th of 2013, less than a year after the Respondent got the license. The Respondent was 22 years old. When he filed his renewal application, he said he had no convictions or deferred adjudications. He testified that he didn't notice that the question asked about deferred adjudications. The ALJ recommends that the Commission deny the renewal application and revoke the license because of the serious nature of the crime, how recently it was committed, and Respondent's blatant dishonesty on his renewal application. Those are the ALJ's, that's his description of the dishonesty, not mine. The Department recommends that the Commission adopt the PFD. I'll take any questions you might have.
Any question, Mr. Rennick? Mr. Davidson, I need you to sign your form. You failed to sign it when you're done here, so that's fine. We can get it here in just a bit. So, but go ahead and state your name for the record.
My name is Dakota Davidson.
Okay, and you've heard me say before, we can only take in consideration those things that were brought before
Correct.
the SOA judge, so go ahead.
I just wanted to say that I said this in the hearing. When the witness had, researched my case and stuff, she wasn't aware that I spent, 52 days. I got arrested May 22nd after the offense, spent 52 days, got out July 9th, went to work at Keesar's Pools a month later and worked for a whole year with my apprentice license before being placed on probation, went to renew it in October, answered the question no, and then was denied the renewal of my license. The witness that was at the hearing was not aware that I spent the 52 days in jail, or when I got out, I went to the detective and cooperated to return some of the property that I didn't have in my possession. I paid $8,000 in restitution to the courts or to the victims. I want to continue my career as an electrician, and depending on the decision today, I have a job at the union, an Alterman in San Antonio. So,
Any questions for Mr. Davidson? Mr. Davidson, you did answer no to the question, though?
yes, sir, I did.
And it was after you had already completed your 52 days?
Yes, sir. I completed the 52 days, and then the court process went on for about
2014, is that right?
2013, I believe.
I'm sorry. Okay, that's right. Well, it says here that you pleaded guilty in June of 2014.
Right, and then I had already been working at that time for 5 or 6 months, and then in the October of 2014, 2014.
September of 2014?
September. When I renewed the license, that's when I answered no and was denied the renewal.
Question I have. Whose habitation was the burglary committed at? Who are the victims that you reimbursed?
Their names were Maxine Crawford and Sophie Vasquez.
And what relationship do they have to you?
None.
Why did you pick their house?
I was hanging around with the wrong group of people, and I was just...
How old are you?
I was 22, sir.
When you responded no, were you hanging out with the wrong group of people?
I'm sorry?
On your application, when you responded no, were you hanging out with the wrong group of people?
No, sir. I responded no because I was told to respond no by my attorney. No, I believe I pleaded no contest in court, and Mr. Rennick said I pleaded guilty. I don't think that was correct.
He's correct. He pled no
Okay.
no contender.
And so your attorney told you to plead no?
Well, they told me no contest.
sorry to
They
answer
they
no.
said no.
No
No contest is deferred adjudication is not a conviction. When I read the question, I read it as, have you been convicted of? And I didn't see the deferred adjudication.
Let me ask a question. Okay, I guess the other question, the only, you were 22 and when you did this crime, and it says something that you were struggling, I guess it says something on notes that you're struggling with drugs and alcohol. What have you done differently with your behavior since the crime?
I recently moved out of my parents' house in my own place. I started studying the code book to try and, if this goes through, I can apply for my wireman's because I believe I might have enough hours. I don't do anything. I don't go out at night. I don't hang out with anybody. I go home, cook some food, watch the news.
So what changed?
What changed about your behavior?
I'm sober.
What about changed about
I'm
about
sober.
you?
But me?
You sober?
Yes, sir, I'm sober.
How long you been sober?
A year.
Okay. What about doing drugs?
What about them?
Well, what about them? What? You tell us.
I don't do them anymore.
All right.
I've been sober for a year since July 27th.
So was there an epiphany?
Yes. About the 14th day that I was in jail. That's not where I want to be.
Any further questions, Commissioners? Mr. Rennick?
I
anything
would
else?
just like to make a couple comments about the respondent's statement here. At the hearing, he said he worked for a pool installation company doing general labor. He said his mother also works there. He said he needed the license to make more money there. He didn't say anything about doing any other type of pure electrical work. Now, I don't know that his plans have changed. I'm just telling you what his testimony was under oath at the hearing. He also said that the reason he committed the crime is that he was on methamphetamine and that he was hanging out with the wrong people. And the ALJ considered his explanation for answering falsely on the renewal and did not buy it at all. So, that's it.
Any further questions for Mr. Rennick or Mr. Davidson?
I didn't sign anything, but.
Yeah, I need you to fill out a form.
I can.
Yeah, if you don't mind, we need you to fill out a form and hand it and
Okay.
also, but go ahead and, if you have, may
just-
state your name for the record, please.
Yes. My name is Linda Combs, and I'm his grandmother. And we went through a lot with this a long time ago, with all the mess thing and getting involved with, thank you, those other guys and everything. But I can tell you that I'm from the bottom of my heart, he has been straight, clean, and sober. And I am a Christian, and
Just
I
want the
mean that
commission to
from the
know this
bottom of my heart.
isn't from the record. It's just, she was not at the hearing.
You were not
Just
at
letting
the
you know.
hearing?
Excuse me?
You were not at the hearing?
What hearing?
The
You mean-
SOA hearing that we had, you weren't at the SOA hearing?
No.
Okay, we can only bring forth
But I
any
was at
evidence.
But we can only bring forth evidence that was at
Sorry.
the SO hearing.
I'm sorry, I don't
So,
quite understand all that, but
okay.
just wanted to say
Thank you very much. Appreciate it.
thank you.
Any other questions? Mr. Rainey, thank you. Mr. Davidson, you go ahead and have a seat.
Thank you.
Hey, if you don't mind signing this, I appreciate it. I've got a pen right here if you need it. Thank you, sir. Yes, sir. You can have a seat. Commissioners' discussion or a motion would be in order.
It's a hard one. I mean, these people come before us, they've been given a license to go into people's homes and do electrical work with that implied trust that the state of Texas is watching over them. And this guy, just like the gentleman a while back, comes up here with his parents. He's been given everything. He's worked hard to get this license, and now wants everybody to forget what he's done, and say, "Oh, I'll go into a home and behave this time." And it's tough, and you bring shame on your family. The good name of Davidson. And I'd be embarrassed if I were you coming up here in public and acting this way. And you've got, it's frustrating.
Any other comments? And of course, I echo Commissioner Butler. I mean, I think that this is it's a difficult position that licensees place us in, because we understand that this is your livelihood, this is what you're trying to make a living at, but at the same time, we have to look at what's in the best interest of Texas, and I think it's a travesty to even have to be at this point.
Especially when you're so young.
Especially so young,
Yeah.
even more so. Commissioners, a motion or any further discussion?
What is different about giving him a chance and the person before him?
Well, we're only talking about this case, Commissioner Vogel. So if there's a motion that you would like to present, we'll be able to hear it and then entertain it.
I think the difference is, for me personally, is that you're in strangers' homes. It wasn't like it was a personal issue that's personally where it's coming from me.
Yeah.
Yeah.
So a motion, Commissioners?
Close to, very close to the time.
Yeah.
Needs a little more time.
Commissioner Shaw.
So, if the commission did decide to adopt the PFD, the applicant can always come back at a
They can always
future
come back and
date
apply, yes.
and make an application. Counselor, can you answer to that, please?
If a license is revoked, the person whose license is revoked can reapply 1 year, a minimum of 1 year. He has to sit out, and then he can reapply, and then we'll assess his situation at that point if he does.
As always, thank you, Counselor. I'm ready to make a motion. I'm going to make a motion to adopt the PFD as issued by the ALJ.
We have a motion to adopt the PFD.
I'd second.
A second. Any further discussion? All in favor signify by saying aye.
Aye.
Those opposed?
No.
Kay, do you mind just taking roll right quick, please?
Tom Butler,
Aye.
Luann Morgan,
Aye.
Fred Moses,
Aye.
Catherine Rodwald,
No.
Robbie Shaw,
Aye.
Deborah Yurko,
Aye.
Mike Harris Mendez.
Aye. The motion passes 6-1. So I think you've heard the discussion. Your license has been denied, but you will have the opportunity to be able to apply again in a minimum of 1 year. Yeah, about September next year. Thank you, sir. Appreciate it. Let's move on to agenda item 11, Carl Clark. Is Mr. Clark here, or anyone present for Mr. Clark? Mr. Sharp.
Thank you, Mr. Chairman. Commissioners. My name is Ken Sharp. I'm with the Enforcement Division. The applicant in this case is Carl A. Clark. On June 27, 2014, Mr. Clark applied for an incident management tow operator license, and the department denied his application because of his criminal history. The administrative law judge concurs and recommends the denial of Mr. Clark's application. In 2007, Mr. Clark was convicted of disorderly conduct. In September 2013, Mr. Clark was convicted of credit card abuse. In that case, Mr. Clark had incurred a bill of $681 at a resort and charged it to a canceled credit card. Although when contacted about the problem, he initially promised to pay it, he failed to do so, even after the complainant made numerous attempts to collect that debt. Mr. Clark was sentenced to 2 years in state jail, but the court suspended the sentence and placed him on community supervision for a period of 4 years. Also in September 2013, Mr. Clark was convicted of bail jumping. He committed this offense by failing to appear for his credit card abuse trial after he had been released from custody on bail on the condition that he appear for trial. The court sentenced him to 10 years in prison, but suspended the sentence and placed him on community supervision for 4 years. In May 2014, Mr. Clark was convicted of unauthorized use of a motor vehicle and sentenced to 365 days in jail. He was given credit for time served and released from jail in May 2014. The ALJ concluded Mr. Clark had not demonstrated that he has the requisite honesty, trustworthiness, and integrity to establish his fitness for licensure and recommended denial of the license application. The department recommends the commission adopt the proposal for decision. Thank you.
Any questions for Mr. Sharp? Motion be in order.
So moved. I recommend that the PFD be adopted as recommended.
We have a motion and a second. All in favor signify by saying aye. Those opposed, motion carries. Item G11, Mr., is it Fikru?
That's
I
right,
think
Mr.
they
Fikru.
requested a, didn't we see that where they requested a?
An email.
Yeah.
Oh, here it is, right here.
His mother passed away and they were asking for a suspension.
Here it is, right here.
Continuance.
Thank you.
Continuance.
Continuance.
That's right. He called yesterday and said that his mother passed away about a month ago, and he's still occupied with those matters.
So,
I
and
wouldn't be opposed.
I don't suppose you have any problems with this?
No.
Okay.
No, sir.
If commissioners are okay with this, we'll move this to the next agenda or the next meeting. So, that sounds good. Let's move on. We're now in the motions for rehearing. Let's kind of push for a little bit more.
Mr. Chairman, we did have Mr. Thompson, Mr. Boyd Thompson.
Did he
One that-
finally show up, or?
I don't know. But we save that
Mr.
for last.
Thompson present?
He's the one that had the car problems.
Right.
I
Let's
don't-
go through some motions for here and see if we can maybe get through some more of this. Thank you, sir. Let's go into item H1, Rodney Wooten. Okay, go ahead and have a seat up here, sir. We've got general counsel coming up.
I have motions to read.
You said that.
We're now in the motions for rehearing. In this particular case, and of course, Mr. Wooten, you're up here already, but just so you know, in the motions for rehearing, the only thing we can do is consider where the department may have erred in coming to their decision. So we're not allowed to retry the case unless there's any new evidence being brought forward. If it's the same evidence, we're not allowed to consider that. So if you can restrict your comments simply to the comments of how you feel that the commission came to an error in their decision, that's what we'll consider at this point in time. So, Ms. Lindquist, if you don't mind, let's move forward.
Good afternoon, Commissioners. Della Lindquist, Deputy General Counsel. Are you Mr. Fisher or Mr. Wooten?
Mr. Wooten.
Okay, thank you. Mr. Wooten had been represented by counsel who filed the motion for rehearing. I just wanted to make sure
Okay.
who was here. This motion for rehearing is a result of a hearing before an ALJ in which you adopted the PFD without modification based on his criminal offenses. Essentially, the motion for rehearing, essentially the attorney's motion alleged some error in the hearing in that certain information should not have been let in, that there was not a guilty plea on one of the documents. A review of the record, when I listened to the hearing, indicates that everything that was let in should have been let in according to the judge, and he did plead guilty according to the documents therein. And they actually discussed the nature of the offense which took place close to or near the barber shop. So we recommend denying the motion for rehearing. We see no error.
Any questions from Ms. Lindquist? So, Mr. Wooten.
Yes, I mean,
If you don't mind, state your name for the record.
Rodney Wooten.
Okay, go
I
right ahead.
pleaded no contest in court also to get the deferred adjudication. I mean, I ain't plead guilty to anything. I mean,
Okay.
I mean, I have changed since then. I'm no longer doing those kind of activities. I mean, it's a privilege and an honor to be a barber in Texas. I learn every day, and I'm just trying to move forward with my life. And
Mr. Wooten, did you, based on the information that was brought forth at the hearing, and I believe this is this was a hearing, correct?
Yes.
Okay. Do you find any place that the commission erred in coming to their decision?
yeah, I think so because.
And I understand you're trying to keep your license, I understand it completely, but what we can only consider here is how we made, if we made a mistake in coming to that decision.
I mean, because I wasn't selling. I mean, they said I was selling, and I wasn't selling anything. I was trying to get something, and I didn't tell on somebody, and that's what they wanted me to do, tell on someone, and I didn't do it. I took it.
Okay. Any questions for Mr. Wooten?
So, Wooten,
I do have, I'm sorry.
Well, Wooten, how long have you been a barber?
I've been a barber for about 13 years.
Any other question, Mr. Wooten?
I do have one
Ms. Gleason,
additional thing
yes.
to add. There was a technical error. The prosecution apparently only needed to, or sought to revoke the license and not renew. The ALJ does, in the conclusions of law, mention renewal. So when you go to deliberate or make your motion, we would recommend removing conclusion of law number 6 and amending conclusion of law number 9 to remove reference to 514012, which discusses application factors, and also removing the word renew, because we only sought to revoke the license, not renew, or deny a renewal.
So, okay, so we sought to deny the
Revoke, only.
Okay, so we sought revocation.
Yes, and for
Okay.
whatever reason, the judge a couple of times in the conclusions of law alluded to denying a renewal.
Oh, okay, I see. Any other questions for Ms. Lindquist or Mr. Wooten?
Now, this was a default. This mean that there was a hearing before SOA and he did not show. Nobody showed up.
This was not a default.
No?
This was, he's filing a motion for rehearing alleging error in the actual SOA case, which is unusual. You don't see a lot of them. Most of what I bring up here are defaults, but
Right.
this was a SOA case in which his attorney alleged some error in the actual hearing, alluding to, again, a plea of guilty or not guilty on some documents, which I have here to show that he did, in fact, plead guilty. The attorney was alluding to the fact that there should have been no discussion of the offense. He was not represented by an attorney at the hearing. The judge gave him every opportunity to testify, and they did enter into a discussion about the nature of the offense, and there was no objection raised to that. So we see no error.
So, Mr. Wooten, you had an attorney submit this on your behalf?
Yes.
And-
Yes, sir.
And is he
I
still?
couldn't afford the fee.
For him to come here?
Yes, sir.
Okay. Any other questions for Mr. Wooten? Thank you. You can have a seat, sir. A motion will be in order? Or any further discussion?
Just some discussions. This is also a very difficult case. And my reading may be incorrect, but the reason why the attorney is filing for rehearing, Counselor, is based on couple of things. Number one, the word speculative.
Mhm.
He mentions the word speculative, and he has some discussion in there about that. And the fact that whether the respondent pleaded guilty or not guilty, and what, the verbiage that was used in that. Am I correct?
Yes. Yes, and I do have the order. The judgment for the particular case he's concerned about that indicates that the judge circled guilty, if you wish to see that.
Okay.
Is that the case that where here it says number 5, where his attorney is saying he didn't plead guilty, but there it says he did? Is
Yes.
His number 5 is the same as that?
It's the delivery of marijuana, the case number 59209 from 2012. I have what was introduced into evidence, if you wish to see it.
Would you want to see that, Commissioner Rodwell?
No, I'm just trying to understand why his attorney wrote that the court did not find that the evidence substantiated his guilt when the document says it did.
I can't answer that, but I don't understand. I don't know.
Any further questions or a motion would be in order?
Move to deny the motion.
We have a motion to deny.
Second that.
And a second.
But I think there might be some technical issues. Do you mind if I add to that motion before you second it? Okay, amend the decisions to remove conclusions of law number 6 and amend conclusions of law number 9 to remove reference to 51.4012.
And the word renewed.
And renewed, correct.
Commissioner Butler, are you okay with those amendments? Yes, sir. So we have a motion and a second. All in favor signify by saying aye.
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 Those opposed, motion carries. Mr. Wooten, your motion for a rehearing has been denied.
Mr. Chairman, can you call that motion?
I'm sorry?
Can you call the vote, please, again?
Ms. Kay, if you don't mind.
Tom Butler,
Aye.
Luann Morgan,
Aye.
Fred Moses,
Aye.
Catherine Rodwell,
Aye.
Ravi Shaw,
Aye.
Deborah Yurko,
Aye.
Chris Mendez.
Aye. It says 7-0, your motion for rehearing has been denied. So if you want, you can get with staff and they can kind of tell you which process you have next. You do have the ability to appeal this to a district court if you so choose, Mr. Wooten. Thank you, sir. Move on to item 2, which is, of course, as we affectionately known as the Aveda case.
Mr. Crum.
So, and Mr. Crum, as you've heard me say, what we do here is we kind of just consider those items where you feel that we may have erred in coming to our decision. I think we've tried the case the last time. I wouldn't say ad nauseum, but pretty dead and close. So if you don't mind, we'll just kind of proceed from there. So, Ms. Lindquist.
Good afternoon. Opposing counsel did prepare a letter. I just want to make sure all of you have seen that. And it discusses a little bit about what may or may not be presented at the motion for rehearing. I disagree with some of his conclusions about it. This is a trial de novo. I don't believe it is. But you are allowed to hear some evidence or information as to what he believes is his error that he's alleging. But I don't believe it's in de novo. There's going to be, that's a whole different thing, meaning to me, like a brand new trial or hearing. But anyway, he asked to present that, and so we did. This motion, or this matter came before you almost a year ago. You issued a decision September 24th, 2014. A motion for rehearing the first time was granted on March 4th, 2015. You issued a new decision on April 15th, 2015, which mirrored your previous decision in September 24. However, it reduced the penalty to $2,000, finding the violations that the department had alleged against him, saying that he should not have demanded the payment of the additional money from the student, You agreed that it was a violation that he did not provide the students with a refund policy that complies with the law, or publish a refund policy that complies with the law, and you failed to maintain, that the school failed to maintain a refund policy that complies with the law. So what we're dealing with now is a second motion for rehearing. And the General Counsel acknowledges ambiguities, issues in the statute. However, you have the deference to interpret the statute within reason, and based on the ALJ's determination, we recommend denying the motion for rehearing.
Any questions for Ms. Lindquist at this time? Mr. Crum, it's all yours.
Thank you, sir.
If you don't mind, state your name for the record.
I don't mind at all, sir. My name is Edward Cramp, and I'm with the law firm Duane Morris. I'm here today on behalf of BD Basics, Inc., doing business as the Aveda School in Dallas. Folks, I'm sure I'm not the only one here who feels a little bit like Bill Murray in Groundhog Day. In fact, as my alarm went off this morning, I'd swear it was the same Kenny Chesney song that I heard 3 months ago when I was here. But that may not be the case. Without belaboring, obviously, the very strongly held beliefs that the school does in terms of what the law actually is, or what we think the law should be as interpreted, we do have some specific points in the decision that was made by the commission last time we were here that we'd like to point out and ask that these be reconsidered. The point of this exercise is not so that we can relive all of this. The point of having this motion for rehearing and have it reheard and all that is to make sure that we get this right. Get this right for the students in the state of Texas and get this right for institutions in the state of Texas. Because frankly, the outcome that we have currently just doesn't work. And it won't work if it stands, and so we'd encourage you to reconsider it and follow the law as written. The part of the decision that I'd like to point you to starts with conclusion of law number 7, and then I'll go on to conclusion of law number 10, and then also bring you back to finding of fact number 8, all of which have to do with the term period of enrollment. In conclusion of law number 7, there is a misquote of the law. Conclusion of law number 7 cites to section 1602.458 of the Texas Occupational Code, section B1, and it only, under the parentheses, and I'll allow you to get there on your iPads if you need a moment, but the parentheses there cites part of the law but not the complete law. The part cited is, quote, or well, I'll just read it out loud. A licensed beauty culture school must maintain a refund policy that, paren 1, is based on the period of the student's enrollment, comma, computed on the basis of course time expressed in clock hours, comma, and paren 2. And then it goes on. There's a phrase, there's a part of that first clause that's missing there, and it's really critical. And the part of the clause that's missing should come after scheduled hours, and it should say, as specified by an enrollment agreement, contract, or other document acceptable to the department. And here's why this is critical. The entire case that the department has built its case, the entire premise that the department has built its case on is that student refunds should be issued on the basis of time that the students are in school, as opposed to the time that's expressed in the contract that is the period of enrollment. The contract says that the period of enrollment is 1,500 clock hours. 1,500 clock hours. The provision in the law says the refund is based on the period of the student's enrollment, comma, computed on the basis of course time expressed in scheduled hours, comma, as specified by an enrollment agreement, contract, or other document acceptable to the department. By omitting that last part, it changes the law from relying on the period of enrollment as expressed in the contract to relying on a period of enrollment that is something else. So that error there unravels the entire decision. And if we don't make that correction, and it's again critical to the underlying premise of the department's argument here, is that the refund should be based on the time the student is in school as opposed to the time that they contract for, which is the entire length of the course. And that same error is repeated and echoed in conclusion of law number 10, and starts in finding of fact number 8, all of which contain that same term, period of enrollment. So that's our issue today, sir.
That's all you got?
I have more. Would you like to hear more? No, I think we've covered the rest of our positions in the papers that we presented to you. I mean, really what we're looking for here is some concrete guidance on how we can consistently apply the refund provision to all of our students so that we don't run into a situation where we have people who attend programs for equal amounts of time that end up paying different amounts of tuition based on the arguments that the department is asserting. And we think that this outcome leads that way. Yes, ma'am.
I have a question. So was it asserted by you in the hearing that every student pays in full up front? Or is it some pay in full up front and some don't pay? So if they were clever enough not to pay up front, that they're okay, but the ones that paid up front are not?
Yes, ma'am. If I mean, the point is that their students pay for their tuition in lots of different ways. Some make payments every month, some make payments as time goes on, some make payments at certain periods.
Right, correct. But are you saying then, if those kids who made arrangements to pay periodic payments, they get a free pass and don't owe the balance due, and only those that had the financing put in, or that saved their money up ahead of time and gave it all to you, they're the ones that are just out of luck and they don't get it back?
Well, that would be the outcome of this decision. If this
It seems a
decision
little
stands.
inconsistent.
Absolutely, you're right, it would be inconsistent.
Okay.
Yeah.
I mean, I just didn't think the legislature would want that inconsistency by intent.
Right, we agree. We don't think the legislature did want that inconsistency. We think that once somebody enrolls and they pass the 50% threshold, the legislature intended that all students, regardless of whether they paid their money up front or whether they failed to pay their tuition up front, should owe the same amount for the contract that they signed. And so that's the fundamental error that we think that the commission's decision that currently is out there embodies. So we think that what the law says is that once a student enrolls and they complete 50% or more of the program, then the balance of the contract is owed regardless of whether the student has paid that money, physically paid the dollar bills to the school. The commission's current decision is that if the student has paid those dollars to the school gets to keep them. If the student hasn't paid those dollars to the school for whatever reason, they're delinquent, they just chose not to, they had a payment plan, then the student would not owe that money. And that's where we think that there's an error. So to be more concrete about it, if you have two students who complete 70% of the program, one of whom has paid 100% of tuition and one of whom has paid 25% of tuition, the student who paid 100% of tuition would be out of luck. The student who paid 25% of tuition would basically get to walk away scot-free and not have to pay anything else to the school, even though they receive 70% of their hours from the school, and even though other parts of the code say that once you complete 50% of the hours that you've scheduled for, then the school is required to re-enroll you to complete the program for free. So that same student who only completed 25% of her hours would be able to go back to the school, demand that she be re-enrolled, and complete the program for free. And under another part of the code, which is section 1602.461, reentry of student after withdrawal or termination, that student could demand to complete the course for free. So, and we think that when you read that later section in conjunction with these other sections, 458 and 459, it makes more sense, in fact, it only makes sense if you read all of that once a student completes 50% of the program or more, then he or she owes the entire balance of the tuition contract. And it's really consistent with what we see, you know, if for those of us who are lucky enough to go to a traditional college or university, you go into a semester, once you cross that magical withdrawal time frame, whether it's 3 weeks or 4 weeks or 5 weeks into a semester, once you pass it, you owe the entire tuition for the semester. It's not like, you know, the community college is going to let you get away with not paying the rest of the tuition for that time period. Does that answer your question, ma'am? I apologize.
Thank you.
Mr. Arizmendez, you asked if I had additional.
I figured you probably would. Do you see where there is ambiguity in the statute itself?
I think the statute is unclear, but I don't think it's ambiguous in the
Why is
sense.
that?
Because I think when you read the statute as a whole, and you read the actual language, and you take out that phrase from section 458B1, it's clear that the period of the student's enrollment is that specified in the enrollment agreement, contract, or other document acceptable to the department. And so that means that really we're looking at the period of enrollment as the entire 1,500 hours that the student is enrolled. Once you realize that if a student completes more than 50% of that 1,500 hours, that is the period of enrollment, that triggers the refund provisions contained in the other section, and that leads us to conclude that the student owes the balance of tuition. I think also important, as I think Commissioner Shaw pointed out one or two hearings, or maybe 3 hearings ago, there is a section that provides for a pro rata refund based on completion at certain benchmarks, 10%, 25%, and then 50%, if I'm getting it correct from memory. There's nothing beyond the 50%. So it's kind of common sense that if you have something for pro rata at 10, 25, and then 50, then once you get 50, you ought to be able to not only keep what you've been paid, but also collect what hasn't been paid to you at that point, because you've earned the entire tuition that was promised you in the contract.
But the interpretation by the agency, where I think you can see that GC says that there is some ambiguity in the statute, but it's an interpretation of what the agency, how they interpret the statute. And the interpretation of the statute, I think, is where we base ours on and moving forward in that particular position. So, based on how we interpret the law, or the agency, and basically kind of the majority of the commissioners have stated that we're still correct in the way that we interpret it.
I don't think the interpretation that's been forwarded is correct. And to the extent that there's any ambiguity, I mean, certainly the languages could be more artfully drafted. I mean, I know that there were attempts this latest round with the legislature being in session to clarify the language, to change it. Those attempts unfortunately didn't go through. But to the extent that there is ambiguity, it has to be interpreted in a way that makes sense. And it has to be interpreted in a way that doesn't read out of the statute other parts of the statute.
So you're saying we don't make sense?
No, sir, I'm not saying that.
Oh, okay.
Of course you make sense. But I think that if the proposal from the department is an interpretation that leads to an absurd result, and I don't mean that in a derogatory sense of the word, I just mean that the result doesn't make sense, using my 75% completion example that I explained to Ms. Yurko, I think that we then kind of have to take a breath and sit back for a moment and kind of scratch our heads and just say, okay, well, wait, does it make sense that the legislature would have wanted us to interpret this inartfully crafted language in such a way that two identical consumers end up paying different prices for the same services? And that, I mean, that's kind of as layman as I can put it. I'm trying to step out of my lawyer role for just a moment, but it seems to me that the legislature could not have intended that a person who does the right thing and pays their tuition and keeps current would be more harshly treated under this interpretation of the law than a person who decides that they're going to just simply sit back and not pay their bills and be delinquent on their tuition, et cetera. So that's really where we think the rubber meets the road, sir.
Any questions, Commissioner Shaw?
So, again, the motion for rehearing, and I'm just focusing on that first, and I'll focus on my recommendation on what we should do moving forward, because this is an item that's going to keep coming up unless we do something about it as a commission.
Unless Mr. Krebs stops bringing it up.
Correct, because I feel like it will happen again.
Raise your rates, Mr. Cramp, so they won't.
I just love Austin, sir.
So is this something that can be, and this is maybe for staff, is this something that can be remanded back to our board, our cosmetology board, to kind of go back and review this? Because I think a clear understanding of how the industry charges, students is kind of, I mean, it's all over the board. I mean, you give it.
The attorney for Aveda pointed out that during the legislative session that we went forward with a proposal to correct this. That proposal was not taken up by the legislature, which in itself is a sign that the legislature did not want to change it. They did not want to change it primarily because schools came and objected to the proposal that was put forward that would have clarified this issue. The clarification was to follow the Workforce Commission standards for the refunds and not have this unique standard that's in the cosmetology statute. We're followed, right now we're following the black letter of the law, that these words mean that if you have not paid it in, they cannot go back after you in order to get that. What the result would be here is that we are, the commission would be solving a business problem for the schools that did not collect sufficient tuition prior to the 50% level. And that's pretty much where it would stand. And the, I'll refrain from this last comment. I was going to give my opinion on that, but
Thank you.
that's not needed here.
I mean, I don't know what happened with the legislature. I'm not sure that it matters that much for the purposes of interpreting the law, but in terms of the business problem, to the extent that there is one, if we interpret it the way that the school suggests, the risk on collection is on the school, right? So the only solution here, if this decision stands, is that students are going to have to pay more money up front. And that goes against the students. If the students can pay less money up front and pay over time, and the schools are willing to take that risk that they might not later be able to collect, that's a risk for the school to take on. But by taking away that option of paying tuition over time, that's reducing the amount of consumer choice, and that's not really helping the business. It's forcing the business to do something that they don't want to do, which is make students pay money up front for their tuition when instead they could just pay it over time.
So you're telling me that the Aveda Institute would completely change their business practices?
That's a really big question. I'm not sure what you're, but as it stands right now, the Aveda Institute allows students to pay tuition over time and make payments on that. But if this goes through, I'm not sure how they would react, but my advice to them would be to make sure that by the time you get to any threshold where a student's going to cross over into the next part, you're going to have to suspend that student or kick them out of school or something until they pay their tuition to make sure that you can get paid. Letting students stay in school and not pay tuition is not an option.
And understand that, which I've mentioned earlier in one of the previous cases, or I think I mentioned prior to, is that the ability to, if the commissioners choose to not grant the motion for hearing, I'm sure you know this, I just want to put out there that you have the ability to seek further through district court.
Yes, sir,
which
I understand that.
So.
Yes, you folks are so much, no, never mind.
You'd rather be here, I'm sure.
Who wouldn't?
Commissioner Shaw.
Yeah, so I'm ready to make a motion, but I did want to clarify.
Well, I guess
I
the
think
other-
prior to that, if you
Yeah,
don't mind,
that's the-
prior to your
you
motion, I
make
think
a
Commissioner
motion.
But go ahead
And
and
if-
make your statement right quick, and then we'll go to Commissioner
Let me make
Lopez.
the statement and then we'll go there, and I'll let somebody else make the motion. I see it this way. There's a risk for the student and there's a risk for the business. In either way, either scenario. If you pay up front, the student's at risk. If you don't pay up front, the business is at risk. So this is going to become an impasse. I think, again, maybe buyer beware, but maybe the schools need to be a little bit more proactive in letting the students know what the law says and what the law is. And I think that'll prevent a lot of these issues that have surfaced in cosmetology schools. But this is where I stand at. There is a risk for both the student and for the business in either scenario.
Well, but also the student signed a contract, and it seems to me that we never took into consideration that student signed a contract stating that they owed the money. We just looked at the statute, but we ignored contract, which, where's the contract law piece of this whole argument? There was a valid contract that is not being considered here.
And that's really the error in conclusion of law number 7 that we're pointing to, which is that it excludes, in referencing the statute, it excludes the part of the statute that takes into account what the student signed, the contract. So it's a clear error on its face.
Any other questions? Ms. Lindquist, seems like you're chomping at the bit to say something.
That historically, the statute's been interpreted to be more pro-student. We do acknowledge that there are risks either way. But the meaning of 1602, 458 would be, the premise, overarching premise would be that the school hadn't earned the fees if the student hadn't sat through a certain amount of the hours. A period of enrollment is the day you begin the class until the day you leave the class, and that's defined in the rules. And so the overarching theme would be, and I know we acknowledge it sounds uneven, and it could be uneven, but the student owes what they've participated in or sat through. But when you cross that 50% mark, it does have that result. What you've paid, the school can keep and not need to refund, but they are not permitted to collect more. The statute is silent on that.
Any questions for the linguist? Any further?
Oh, I guess the only other issue, I think it sounds like a, and whether we correct it, sound like a statutory issue, but it also sounds like a business issue in terms of the school determining how they're going to do business with the student in terms of collecting money.
And I think,
and setting what instruments in place up front.
And I think it's been stated, not only by, I think, Commissioner Moses, but also Commissioner Shaw, it puts us in a very precarious position because understanding, trying to find that balance between the students and business. I mean, I think that we have to understand is that, I don't think there's anyone out there that's not pro-business and wants to ensure that business flourish, but at the same time, our responsibility is to ensure that we're protecting the citizens of Texas. So there's a balance in there that we're trying to find. I can tell you that I personally think that we did find that balance. In my opinion, this is just so you know how I'll vote, I'm going to vote to not grant the motion for a hearing on my part because I don't think that there's been sufficient evidence brought forward that would change the previous decisions that we've made before. So, I think that there, and as my question was earlier, I believe that there is some ambiguity. And I agree with GC, is that there is some ambiguity in statute and how we interpret those particular words and the definition of that and not having clarity of that. But, I think that as our executive director stated, we are following kind of the black letter of the law and going in that manner, so. A motion will be in order unless you have further questions.
Make a motion that we deny the motion for rehearing.
Second.
We have a motion and a second to deny the motion for rehearing. No further discussion. All those in favor signify by saying aye.
Aye.
Those opposed?
No.
Let's go ahead and take roll. I think it's 6-1, but let's go ahead and take roll.
Tom Butler,
Aye.
Leanne Morgan,
Aye.
Fred Moses,
Aye.
Catherine Rodwald,
No.
Ravi Shaw,
Aye.
Deborah Yurko,
Okay. Denying the motion, the aye is in favor, so aye. Okay.
and Mike Ayers-Mendez.
Aye, so that's correct, 6-1. So, Mr. Grant, we appreciate you coming back again.
good seeing you,
I
Mr.
guess it's
Grant.
probably the last time we'll see you.
Hopefully
I
not
wouldn't
for,
count on it.
hopefully not for my part, sir.
Maybe
Hopefully so
not.
for your part, but.
So,
thank you.
but
It's been a
again, as
pleasure.
I mentioned earlier, you get with staff and they can kind of tell you, I'm sure you probably know what your next level is if you so choose.
Yes, sir, we'll be
So,
on it.
all right, thank you,
Thank you.
appreciate you coming in.
Have a good day, yeah.
Thanks. I think we got you out of here by 12.
Thanks, sir.
Let's move on to item H3. Lindsay Cannon, I believe you're here. Come on up and have a seat. Ms. Lindquist.
Okay, this is a default, motion for rehearing based on a default order. We did send the notices to the correct address, however, apparently the respondent alleged that she moved and did not update her address with her. She did pay the $300 penalty that was owed in the previous case that was the cause of her revocation. So in keeping with previous decisions similar to this, we could recommend, since there was no error on our part, you could deny the motion for rehearing, but probate the revocation for 6 months, consistent with some other cases of this nature.
Any questions from Ms. Lindquist?
I'd so move.
Okay.
Okay.
If you don't mind withdrawing that, we
Okay.
do have her up here.
I'm
I'm sorry, if you don't
sorry.
mind. If you don't mind, state your name for the record. And
Lindsay
again, as we
Cannon.
mentioned earlier, you can only bring forward those things that you feel how the commission erred. I think you heard kind of what she was saying, that we could go ahead and deny the motion for rehearing, but go ahead and order a probate for revocation of your license.
Okay, so that is kind of like what you were talking about earlier.
where?
It would allow you to work.
Okay,
Yeah.
okay.
So I don't know if you want to say anything, if you just want to let it go
Well,
with
I
that.
mean, I don't think it was any of
So
y'all's
you'll leave
fault.
it at
I
that?
got a divorce after 17 years, and I wasn't getting my mail, and I didn't do right, so once I got the notice at work.
So you're okay with what we're saying?
Yes, I'm
Okay,
good.
so you basically didn't have any testimony at all?
I don't.
Okay, sounds great.
so.
Thank you.
And have you updated your address?
Yes, ma'am.
I'm sorry, no, you had to make
So,
a motion.
okay, so I'll move to deny the rehearing, the motion to rehear, and to modify the order to probate the revocation for 6 months?
Yes.
Okay.
So we have a motion
Second.
and second. All in favor signify by saying aye.
Aye.
Those opposed? Motion's granted. So I
Sorry
think you're
to
good.
do anything.
They'll get with you and you'll be able to go from there.
Thank you.
All right,
Okay,
thank
thank
you.
you.
Appreciate it.
Thank
Move
you.
on to item H4, Princess Nails. And I believe, let me see who's here. Is it Miss Vu? V? Vu, okay. Have a seat. Ms. Lindquist.
This is also the result of a default. Apparently, the respondent did mail in the remaining balance that was on the previous order that caused the revocation, mailed it in between the time that the notice of violation and the notice of default were sent. It may have been misapplied at the time, but she did pay that. So therefore, the finding of fact number 4 in our default order was incorrect because it alleged that she had not paid. So we recommend granting the motion.
Okay, so recommendations to grant the motion for hearing. Okay.
Can I ask why we're doing this any different than the last one, since she's already paid in full? Why
It was the timing of her payment.
Okay.
In the last one, the notices were delivered. She did not update her address. We made no error. I'm of the opinion that there was error on our part here because we didn't, for whatever reason, notice that she had paid that $975 very closely to when she got the NOAV and before the notice of default was sent.
Okay.
And Ms. Vu, you might just, I'm sorry, we do have interpret. Identify yourself right quick.
Good afternoon, Commissioner. My name is Bruce Tran. I'm a permit specialist with TDLR.
Okay. If you don't mind, let her know that she's going to get her motion for a hearing. I don't know if she wants to say anything or not. That's what she's requested, and we're going to give it to her. So I don't know if she wants to make a statement or not.
Bây giờ chị đã yêu cầu là yêu bạn nghe lại cái quyết định của giám đốc. Bây giờ đó đây chịu cho nghe lại cho chị có cái gì để chị nói thêm không? Chị cần nói thêm cái gì không? Chị nói vào trong này. Tiếng Anh gì cũng được hết.
Dạ thì em muốn
Do we want to make a statement?
Chị có muốn nói thêm không? Dạ. No.
No? Okay, thank you. So we have a motion, I'm sorry, we have a recommendation to grant the motion for a hearing.
Yes, I have a motion to grant the motion for rehearing.
We have a motion
Quyết định cho
Second.
and a
nghe
second.
coi lại hết.
All in favor signify by saying aye.
Aye. Aye.
Those opposed, motion carries. Let her know she'll get her motion for a hearing.
Okay, thì đây sẽ coi lại cái hồ sơ chị thân nữa.
Okay, you can have a seat. Thank you. Item number 5, LA Nails.
This respondent, apparently, this is a default order, attempted to settle the matter back when it was still with the Enforcement Division, never did sign the settlement agreement or pay. Time went by, and now he's, when he filed the motion for rehearing, he wanted to actually settle and pay the reduced penalty, but it was a little bit late. So all he's actually trying to do now is reduce the total penalty down to the $2,900 that he thought he may have settled for back when it was with enforcement. We recommend there's no error in denying the motion for rehearing.
Is there anyone here representing LA Nails? Is it phone? Commissioners?
So move as recommended to deny the motion for rehearing.
We have a motion to deny.
I'll second it.
Okay, you guys got pretty close on that one. And a second, all in favor signify by saying aye.
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 Those opposed, motion carries. Number 6, Sandra Estrada. Ms. Lindquist.
Okay, this is also a default order. It's similar to the other case. She has apparently paid the $300 fine with GC. So we allege there was no error on our part. However, we recommend that you could also deny the motion for rehearing and probate the revocation for 6 months. Again, she paid way long after the notices
Right.
were given, so it would be inappropriate to grant the rehearing because there was no error, but she
Right.
has complied.
Gotcha. Do you want me to make that motion again?
Is anyone here representing Mrs. Estrada? Yes.
Okay. Move to deny the motion for rehearing, but to modify the default order and probate the revocation for 6 months.
Second.
We have a motion and a second. All in favor signify by saying aye.
Aye.
Motion, those opposed? Motion carries. Item 7, Starline Salon. Is it, are you present? Oh, I'm sorry. Mr. Kidd, Craig Kidd, okay. Come on up.
This is also a default order, and apparently there is a misunderstanding, or we noticed this case against an incorrect person. There's someone with a very similar name in our tulip system, and we also alleged and pled that an incorrect license number that was not hers was revoked. Therefore, we recommend granting the motion for rehearing.
So we have a recommendation to grant.
Yes.
Mr. Kidd, I don't know if you want to say anything at all.
No, Your Honor.
All right, thank you, Sue. And I'm not your owner, but I
I'm
appreciate
sorry,
that.
I said Mr. Commissioner.
We have a recommendation by General Counsel to grant the motion for rehearing.
Some of it is recommended.
Second.
We have a motion and a second. All in favor signify by saying aye.
Aye.
Those opposed, motion carries. Thanks, sir.
Thank you.
Item number 8, is it Centric Nail and Barber Salon? Ms. Lindquist.
Yes, this is also a default order where the respondent has attempted several times to enter into some kind of repayment plan, but to date, she has not paid any of the balance that's owed. We recommend denying the motion for rehearing.
Is anyone here representing Centric Nail? We have a recommendation to deny.
Somebody.
Motion
Second.
and second. All in favor signify by saying aye.
Aye. Aye.
Those opposed, motion carries. Item 9, Alps Group LLC.
This is an EAB case. The second set of violations for this same respondent, that's why the penalty seems higher. This particular case alleges that when his building was inspected after construction, there were some violations. Oops.
Go ahead.
Oh, okay. There were some violations under the EAB law. The notices that we sent in this matter were delivered to the correct address. We see no error. Like I said, in the first case a while back, they were apparently late in getting the building inspected. They did pay an agreed order to take care of that. We recommend denying the motion for rehearing.
Any questions for Ms. Lindquist? We do have Mr. Nguyen, is that correct?
Yes, I'm an attorney from Houston, represent Alpes Group. In this instance, we're requesting a rehearing because the manager at the time, the brother-in-law of the principal was out of the country. The manager was embezzling about $2 million, as we've learned from a forensic accountant. And there was likely going to be a lawsuit about that. The manager was completely neglecting his duties at the time. Since then, everything's been remedied for a total of $340. I spoke with the person who performed the repairs and inspected the site yesterday.
Is this information that you just revealed to us prior to the order?
There was no hearing, so there is no information. There was no legitimate individual who could have responded at the time because this person who would have received the authority had absolutely no authority in stealing money from the company.
So this is a default order that we have before us?
Yes.
We're asking for a rehearing to lower the penalty from $5,000 to something else for a repair that cost $340 to move some grab bars.
Based on information that you received after the default hearing?
Based on
forensic
information
evidence.
information that was not knowable
At the
until
time.
until the past 6 or 7 months when we got the forensics.
Any questions for Mr. Nguyen?
I would like to say something.
Yes, ma'am.
None of the part that you just heard was alleged in his motion for rehearing. I would ask that you not consider anything to do with the staff or what was going on with the manager. He simply alleged that the fine and the hearing was the fine in the default order was unconstitutional because it was higher than what it cost him to make the repairs. This is the second time for this respondent to have apparent issues with being late paying us and taking care of business with the building. So we recommend denying the motion for rehearing.
May I respond, sir?
Yes, go ahead.
I'm new to this practice, being a federal criminal defense attorney, and I was informed by the persons on the phone that no additional evidence could be submitted with the motion, but simply to state the grounds. Otherwise, I would have submitted photographs, affidavits, and everything else, being a practiced trial lawyer.
Well, you did allege grounds, and you brought in some additional grounds today.
Right. I did not attach evidence, documents, as you would to a motion for summary judgment, because I was informed that was not the procedure here. I would be glad to do so.
Any questions?
See, okay, I guess my question would be in terms of allowing the motion for allowing the motion. What's, if there is any drawback to any basins that we should not grant the rehearing?
I think there's a technical issue at this point in time because of the fact that the motion for rehearing filed by Mr. Nguyen simply, as you can see here, alleged that the violations were remedied prior to, on or before September 13th, which he submitted an invoice, and then says that it was unconstitutional based on the fine, but that's it. So I think there's a technical issue of the fact that he's looking for a motion for rehearing now based on information that was received prior to the default order. That's what's being brought forth now at this time, but not based on the motion for hearing that was submitted to us to get it to that point.
What he's alleging is, I believe, that the violations have been corrected subsequent to the default order, but much later than the notices were delivered. Our letter, when we write to the respondent, and here's the decision, and we tell them what the motion for rehearing is about, we tell them to list every reason why you believe the decision is wrong.
And you submitted this letter to us on April 21st?
The record will reflect the date the letter was received. We responded as soon as possible with the new management. Whatever notices were received before were received by the management. I said that the forensic accountants has determined was embezzling money.
So did you know that prior to April 21st?
Did I know that? I was not aware. I submitted the letter shortly after I became aware of the problem.
Right.
And
My question
within
is,
the time
did you
frame.
know of the forensic evidence prior to April 21st?
Prior to, yes.
You did. So that wasn't a part of your reasoning for the motion for rehearing?
I thought that that was incorporated within the grounds stated based on my telephone conversation with the appropriate authorities here. And we would have some opportunity to discuss the problem of the lack of authority of the person who received notices. I also argue that there's very limited prejudice to our proceeding in allowing me to, tomorrow or the next day, submit some affidavits to support this.
You could continue the matter.
We could.
But also, if we give them a chance to grant the motion for rehearing and give them a chance to, resolve the issue, wouldn't have to come before us again. That's where I'm at. I think that we should, it's not that big a deal. Shouldn't do it.
It's an option.
It's an option, I think. So.
But there was no error.
Right.
There was no error on our
on the
part.
Commissioner's part, which is what we're after here. But anyway.
Is this, can I have a question? Is this the second violation?
Yes.
Do I remember?
Yes.
For the same company?
For the same respondent, yes.
Yeah.
I would ask for clarity on that because as I understand it, there were two items. One, the grab rails were off by about 6 inches, and two, the door closer was the wrong door closer by several pounds in order to accommodate anyone with a disability going up to the 4th floor of the storage facility.
So was the violation
That may be a confusing, what is
Consecutive,
meant by
I mean,
two
concurrent,
violations.
or-
We mean there's two, this is the second matter brought before the department alleging a violation against Alpes Group, not that there were two violations in the inspection.
Right.
This is the second case. The first was apparently they were late to pay after the building was constructed when the first inspection is due, and they resolved that with an agreed order and paid. This is now
It's the
the
result
matter
of the
of fixing
inspection.
the violations that were discovered in the inspection.
Okay. That's what I was getting at.
Yeah.
It wasn't a concurrent issue, it was
Two separate.
two separate dates and times.
As a request for lenity, I would suggest that, again, the principal was out of the country and the manager was running his own show and cutting self-deals with the tenants for which he will be held accountable.
Any further questions for Ms. Lindquist or Mr. Nguyen? Thank you, sir. Appreciate you. Can have a seat. Commissioners, motion be in order. Further discussion?
I move that we grant the motion for rehearing. Yep.
We have a motion to grant the motion for rehearing.
Second.
A second. All in favor signify by saying aye.
Aye.
Those opposed?
No.
Can we get a roll call again, Ms. Mahan?
Tom Butler,
Aye.
Lynn Morgan,
Aye.
Fred Moses,
Aye.
Catherine Rodwald,
Aye.
Bobby Shaw,
No.
Deborah Yurko,
No.
Mike Mendez.
No. Motion carries 4-3, so you'll get your motion for hearing. You get with staff and they kind of tell you what you need to do. from there.
I would do.
All right,
May I
thank
be
you, sir.
excused?
Yes, please, thank you.
Vacate the order.
So, let's move on to item 9. I'm sorry, that was item 9. Item 10, Pearland Town Center. Is anyone here representing Pearland Town Center? Go right in. Ms. Lindquist.
This motion for rehearing was the result of a default order. Apparently, there was some transfer of property and some confusion. This office or the department didn't err because we used the address for the owner that we believed was correct. However, there was a transfer of property and the appropriate current owner, N7 Holdings LLC, is actually, should be the named respondent in this matter. And that respondent has contacted us and has acknowledged that. So we recommend granting the motion for rehearing to start afresh and deal appropriately with the correct respondent.
I have a question on that, and I don't have any problem with, I agree with your granting of the motion, that's fine. But I was just kind of curious, because even though they've changed their name, they both were responsible for having these type of architectural barriers done properly, correct?
I believe, and I may be wrong, but I believe that the owner is the one who actually had the construction done. So there was some back and forth between the developer who did own it and saying that you're responsible for this because you have bought this particular part of the shopping center for his restaurant. And so he acknowledges, notwithstanding any of that, he acknowledges responsibility, and he had responsibility at the time the NOAV was sent out. So.
I guess what worries me is if the developer is not responsible, he's going to have the deeper pocket, and if the restaurant just happens to go under and it's gone, we have no way of collecting these fines and kind of making sure, whereas the developer would be one that would make sure all this is being done if it's going to come out of his pocket.
Well, if the developer had been the owner at the time we sent out the NOAV, I would agree, but we are tasked with finding the actual owner of the property is the responsible person when the construction is done, so.
Okay, yeah.
I think the developer sold it out to this person, from what I understand.
Right, but when he sold it to that person, it wasn't in compliance, correct?
That I don't know. I don't know if there had been any construction started at that time.
Commissioner Shaw.
Okay.
Yeah, and I'm ready to make a motion.
Go ahead.
I think based on just what you just said, I think the handoff part, when a construction is complete by the owner slash developer or developer slash contractor, becomes a very confusing sort of process, and so I think it's proper to go ahead and grant the motion for rehearing.
We have a motion
Second.
and second. All in favor signify by saying aye.
Aye.
Those opposed, motion carries. Item 11, Vincent Espelin. We have someone here? Go ahead. Come on up. Is it Jason Danowski? Danowski, okay. Go right ahead.
Laura Pefferly and Charles Johnson for the General Counsel's Office. This motion for rehearing follows a SOA hearing after which the ALJ recommended not revoking the license. The Commission, after deliberation, changed 2 of the findings of fact and 2 of the conclusions of law and ordered revocation. The respondent in the matter alleges that the Commission unlawfully changed the ALJ's findings of fact 23 and 24 and conclusions of law 16 and 17. The Commission's new findings of fact and conclusions of law are contrary to the evidence and to findings of fact 9 to 22 and 25. That the Commission's new findings of fact number 23 and 24 are contrary to law and unlawfully attempt to shift the burden of proof to the respondent, and the Commission failed to consider the factors regarding criminal history in Occupations Code 53023 in violation of the Occupations Code and in contravention of its conclusion of law number 14. Those are the respondent's allegations. The General Counsel's Office is recommending granting the motion for rehearing, adopting the PFD, and reversing the order to revoke.
Any questions for Laura or Charles? Mr. Danowski, hearing this, I'm not sure if you still want to move forward with your testimony at this time before the Commission, or if you just choose to remain silent.
I will do so.
Okay. Any further questions, discussion, or a motion to be in order?
I'd move that we accept we grant the motion for rehearing and reverse the Commission's order of revoke and adopt the ALJ decision for the PFD.
Which would be to not revoke the license.
That's right.
Okay. We have a motion and a second.
Discussion.
Yes, sir. Mr. Shaw.
Just for the record, the reversing the Commission's decision of April 1st, 2015 will be in order.
That's correct.
That's what they're doing.
All in favor signify by some, sorry.
If I may, Mr. Chairman, this motion is for a rehearing, or is this motion to invalidate the vote that the Commission made?
I think it'd be both. It'd be to grant the motion for hearing and adopt the PFD as presented to us by the ALJ.
But why would you need a motion for rehearing if we're going to adopt the PFD?
Because the decision that we had before was to reverse the PFD.
Okay.
The previous
I
decision by
thought
the
we were going to
Commission.
reverse our 4-1 decision and just adopt the PFD.
Yes, ma'am, but I think it's a matter of procedure. In order to get to the adoption of the PFD, we have to grant
okay.
rehearing in order to undo the Commission's prior order.
Commissioner Rodwald, it would be similar to amending a motion that's before, so you have to go back and undo.
Okay.
Any further discussion? A motion would be in order? Sorry, we do have a motion and a second. We get a second? Okay, all in favor signify by saying aye.
Aye.
Those opposed?
No.
No.
Thank you, Commissioner.
No. I think the motion carries 4-3. Let's get a quick vote, though.
Butler,
No.
Leon Morgan,
Would be to grant the motion here and
You're an
reverse
aye
the PFD.
because you-
Can
Grant the motion, aye.
I pause for a second? Let me understand the motion again.
Yeah,
Could the motion
yeah.
be repeated again, please?
The motion is to grant the motion.
Motion for the rehearing
Uh-huh.
and reverse the Commission decisions of April 1st.
And accept the proposal.
And
for
And
PFD.
accept the proposal to adopt the PFD as recommended. by-
Okay, I'm sorry, go ahead, Kay.
I'll change my motion.
Fred
Thank you.
Moses,
Aye.
Catherine Rodwald,
Aye.
Ravi Shaw,
Nay.
Deborah Yurko,
Nay.
Mike Arsenitis.
You got a problem,
Aye. Motion to grant the rehearing is granted, and also reverse the decision of the commission previously and grant the PFD by the ALJ. So, thank you, sir. We appreciate it. Item number 12, Demetrio Morales.
This is a default order. The notice was sent to the correct address. Respondent stated he did not get the notice until he returned from apparently being out of town. However, we sent an NOAV and the notice of default to the same address, the correct address. They both went unclaimed. We see no error. We recommend denying the motion for rehearing.
We have a motion before us. I'm sorry, recommendation. So, motion would be in order.
So move as recommended. That
We have a
deny
motion.
the Motion for rehearing.
Right.
What number?
12.
We're on 12.
Thank
We have a
you.
motion to deny. And a second. I failed to ask, is there anyone here for Mr. Morales? All in favor signify by saying aye.
Aye.
Those opposed, motion carries. Item number 13, A&A towing.
This is a default order. Mr. Collins did attempt to enter into some kind of repayment plan. He's paid previously $1,000 on the $2,000 penalty. However, he has not paid anything for June or July, or to date, he's not paid anything further. We recommend denying the motion for rehearing.
Move to deny the motion.
We have a motion and a second. Anyone here for A&A towing? All in favor signify by saying aye.
Aye.
Those opposed, motion carries. Item number 14, we did receive an email by Mr. Cannon stating that he didn't realize the conflict in schedule. He's currently on vacation.
We
this
understand,
week.
because his was going to be at the June meeting that was canceled, so we acknowledge there could be some confusion there.
So are you okay with moving this to the next meeting?
Yes.
Okay, let's go ahead and move this to our next meeting.
Do we have to, oh, sorry.
Let's go back to G4. Mr. Sharp has Mr. Thompson shown. Commissioners, what's your will? Do you want to proceed forward with item 4, or do we want to push this off to the next meeting? I believe that Mr. Sharp
Push
did
it off.
state that this was a previous issue at the hearing. Is that correct?
That's right.
He did have car trouble then too.
Yes, he showed up. It was an hour late because of his
Okay.
car trouble.
Okay.
So you didn't offer to pick him up for this meeting?
Had I known.
Push it to the next meeting.
Yeah, I'd say, yeah, I'll support pushing to the next meeting.
He showed up once.
Is everyone okay with pushing to the next meeting, or would you
Yes, sir.
want to proceed forward? Let's go ahead and push this off to the next meeting. Thank you, Mr. Sharp. Ms. Mahan, I think that takes care of our contested cases and motions for rehearing. Is that correct?
Yes, you have one more action item, the board appointments.
Oh, yes, let's go ahead and do that one right quick before I start losing my quorum. Commissioners, you do have item S. We do have the approval of appointments for the advisory board. Okay. What Ms. Mahon is passing out to you right now are the correct dates that their terms will expire, so you actually have that before you. I can tell you, I give a lot of credit to Tamala Fletcher for keeping me on the straight and narrow on this here. There has been a lull in appointments to the board, waiting to see what the governor's office, since we did get a new governor in, we decided to go ahead and, I decided to go ahead and proceed forward and do an appointment. So you do have quite a few appointments before you, and reappointments to the Air Conditioning and Refrigeration Contractors Board, Advisory Board, Architectural Barriers Advisory Board, Board of Boiler Rules Board, Licensed Breeder Advisory Committee, Property Tax Consultant Advisory Council, Texas Tax Professional Advisory Committee, Towing, Storage, and Booting Advisory Board, Used Automotive Parts Recycling Advisory Board, and the Weather Modification Advisory Committee. So I would now bring those before you, and we can do one at a time, or we can go ahead and do the full slate of appointments that I have before you. but at this point in time, I would entertain a motion.
Make a motion that we do the full slate.
Second.
We have a motion and a second. All in favor signify by saying aye. Aye. Those opposed? Motion carries. Commissioners, I would also let you know, if there's anyone in your particular area or that you know of somebody that would be interested in some of these boards, please let them get in contact with Tamela, or encourage them to get in contact with Tamela. Or you may know someone that's interested in that particular industry also. Let us know. I know that we have some commissioners that have been pretty active in getting people on the boards. And so any help in that would be greatly appreciated, because as you see, all these boards that we did appoint, there's some additional boards that we still have to appoint, and then we have about 7 more that will come down the pipe coming in about September or October. So there's quite a few that we still have. We currently have 19, I believe there's 19 boards, advisory boards, and then we're going to be tacking on an additional, I believe, 8, so we're going to be up to about 27. So if you have any names, I would more than welcome those to come forward. So before, well, let's go ahead and let's move on to our staff reports. I think, is everyone still okay on time? Are we okay on time? Okay. So why don't we go ahead, I know that some of you may be going in and out, having to go out and maybe doing the restroom, but let's go ahead and move on with our staff reports with the bill.
Mr. Chairman, members, I'm Bill Koontz, your Executive Director. We have quite a few things that are going on with the agency because of the new programs that are being sent to us, and we're in the process of doing a lot of job posting and hirings. We're ramping up so that on September the 1st we can start right away with the driver education provisions that we're receiving from DPS and from TEA. The transfer of programs from the Department of State Health Services is delayed beyond the normal implementation period that we would have, because we try to do implementations at the beginning of the fiscal year. The Department of Health is a larger agency and moves a little bit slower than we do. So to get the handoff, we need to shoot for a date of March the 1st for transfer of the 6 programs coming from Department of Health Services.
What are those 6 programs?
The hearing fitters for hearing aids, the athletic trainers, the how can I forget this? It's the midwives. And being Lamaze trained, I know quite a bit about the midwives issue. The massage therapist, the dietitians, and it's the orthotic and prosthesis fitters. So it's a diverse group of medical-oriented, and it will change the way that we handle our license programs, in that in all of these you have standards of care. There are issues that need to be evaluated, so that we will have some different ways of overlooking what the licensees are doing, so that we can evaluate on standards of care, much as they do now. That's not something that you have in the license programs that we have now. So it's a little bit of a modification, but they are straight-up licensing programs. It's within the core competency that we have, and we're looking forward to success on that implementation. We've beefed up our staff. Earlier, I was pointing out that we have now a Deputy General Counsel, and Della was able to visit with you during the executive session. In addition to that, Delia Luna, Delia, if you'd stand up. She is now going to be working with Tamela on advisory board support. Tamela is going to move over to this facility, so that she and Delia will be resident here, so that when the advisory board meetings are taking place, that they're right here on the spot to take care of it. And we do need to spread the load on the advisory boards, because we're adding now to the 19 that we currently have. We will have an additional 7 more advisory boards coming to us. So we're rocking right along on that.
And that's going to be welcome support on my behalf too. So
yes.
I tell you, I spent almost 2 days trying to get these advisory boards and talking with the folks and getting information from them. So I think that they're expediting the way we're going to be doing this, but also, as I mentioned earlier, I think that's why it's imperative, if you have someone, let me know, because I'll rely on you to be able to help me out there.
Right, and then we have a new member of the Office of Innovation, Gina Garza-Riordan. Gina is a Six Sigma black belt, so now we are back up to strength in having 3 Six Sigma black belts on staff. So we're able to really do some analysis and look at new innovations that we want to bring forward for the agency. So we're now really positioning ourselves for moving forward in the future. We're also doing staff development. Ray Pizarro has been accepted into the Governor's Executive Development Program. We have quite a few graduates from that. Just about all the division directors have graduated from that program, as well as Brian and myself. And as an agency, I think that we are unique in that we have that many graduates from that program. And additionally, Randy Nesbitt has been accepted into the Transformative Leadership Program. Brian and I have done that program in the last 2 years. That's a very intense program. It's over a 6-month period of time, and it really pushes you during the. They have 2 one-week intensives where you're pushed all day long on coursework that's going on. Then you break and have a discussion hour, happy hour after that, go to dinner, and then you're expected to journal what you heard and learned during the day, and then go to class the next morning. When I went through that, I was journaling at 3 o'clock in the morning because I needed to take a nap after dinner in order to be able to really think straight and get things done. But it really works you out. There's a lot of reading that goes on with that, and some of the readings that we've done for the book club have come from that. The book club, we've had a new book, How the Mighty Fall. That came about because of a speaking gig that I had with the University of Texas at the Executive Masters in Public Leadership. In that, they were talking about how we do measures and what we look at as far as our successes are concerned. And we had a discussion about some of the proxy measures that we did. One of the proxy measures was recognition by the Quality Foundation, which does the Baldrige criteria. When Lillian Norman Keeney was on the board or the commission, we had some discussions with her husband John about the Baldrige recipients and how several of those Baldrige recipients had gone bankrupt. In the discussions in class, we were talking about some of the companies that were recognized in Good to Great by Jim Collins, and some of those have fallen and gone into bankruptcy or declined and then came back out of that decline. That got me really thinking about that issue, because we're pretty much in that we've reached the peak, we're recognized by the legislature, we are running on all cylinders and everything's going well, and said, what do we need to pay attention to? And the book that I came up with on that was How the Mighty Fall, and it is spot on for what we need at TDLR to keep our focus, to be sharp, so that we don't get complacent and we don't let things slip up on us where we could end up stumbling. So we've had a discussion of that in the book club yesterday. It was a great discussion. I think that book plus the Mistakes Were Made were the 2 books that have been most instrumental recently in the development of our staff at TDLR. So I think that this How the Mighty Fall, and it's a very short read. Half of the book are notes and appendices on the analysis and how he identified some of these companies by comparison. So you get on the airplane and you can finish it before you land. It's been a really good book.
Well, it depends how fast you read also. I didn't get to finish.
And if you know how to read.
And if you know how to read, I didn't get to finish.
Well, we've also identified a speed reading course that we can take online, if that'll help you, Mr. Chairman.
Are we licensing that one too?
Don't give anybody any clues.
So those are the things that I've got to share with you. I know that we've got Christina wants to talk about some of the, or I've asked Christina to talk about some of the
Yeah, she may not want to, you just asked her to.
some of the successes that the Enforcement Division has had. And then Susan Stanford has a project that they were just finishing up yesterday that I want her to brief y'all on so that you'll see it at the next meeting.
Ms. Kaiser,
Good afternoon.
1220.
Mr. Chairman, Commissioners, I'm Christina Kaiser, the Director of the Enforcement Division. Wanted to highlight first some of the key statistics that are presented to you in my staff report. The first two numbers that we show for you are the number of cases opened and the number of cases resolved, and we show you those for this fiscal year through the end of June as compared with last fiscal year through the end of June. And I wanted you to just take a look at the relationship between those numbers. Last year at this time, the number of cases opened was much higher, about 1,600 higher than the number of cases resolved, whereas this year, the number of cases resolved is much higher, about 2,600 cases higher than the number of cases open. That is a good place to be in. We always want to have more cases coming out as resolved, coming out at the tail end of the process than coming in at the front. Because when you have more cases coming in than are going out at the end, what do you get? You get blockage in the middle, and you got too much going on and you can't keep up with everything. So that is a really good position to be in. I want to credit three things to that. First of all, these lawyers have been working really hard. I think last time I spoke to you, I talked to you about a sort of a renewed emphasis we were making on taking steps that would lead to cases getting resolved and closed and out of our hair. These lawyers have really taken that charge and run with it and have just done a tremendous amount of work. Another thing is last year, Bill and Brian were kind enough to let us add 3 more lawyers to our ranks, 3 attorney threes who have focused on the inspection-related cases that come to us from cosmetology and barber and tow truck and vehicle storage facility programs. They have really helped us to shift some of the workload around and move cases more quickly, allowing some of the other lawyers to focus on the cases that might be a little more complex. And the third thing is we've just had a little bit of a lucky year. The number of consumer and other types of cases that come to us from the outside world is just lower this year for whatever reason. The number of inspection-related cases is not dropping. The number of criminal background type referrals from the licensing division is not dropping. But consumer complaints in some of the programs that we regulate that bring us the majority of our work, such as cosmetology, barbers, air conditioning contractors, and a few others, are just lower. So for whatever reason, that's given us a little bit of a help. I wanted to highlight a couple of other numbers that are just really significant that I did not reference in my report, and it relates to this same discussion about moving cases through the system. The prosecution section, when we started in June of last year with this push of trying to move cases, we had more than 6,000 cases open just in the prosecutor's hands. As of July 1st, we have 4,000. So that's a drop of 1/3. That is a big deal. That added with having more prosecutors on staff means things, can only help, but, can only help look better. Similarly, the investigators have done a similar push in the last few months. In September of last year, the investigators as a group, and there are about 36 of them, had 2,200 cases open in their hands. As of July 1st, they have 900. So they are also moving a lot of the old stuff, and we've been talking with the prosecutors. Okay, the investigators are making this big push now, so you're going to be seeing some old stuff coming out of the investigators' hands, so let's not lose our momentum. We have to stay on top of this and stay on task with what we've been talking about. The other thing I would like to mention to you, I'd like to tell you about a few recent hires we've made. You've probably seen the fairly aggressive hiring schedule that we have for the next few months as we're trying to fill new FTEs. Enforcement has only had 2 recent hires that come out of that. One of those was to replace Mary Winston, who recently left she's one of our prosecutors, and she recently left the Enforcement Division to join the Office of Strategic Relations and Communications. That's part of the Executive Office. So to replace Mary in an Attorney 4 position, we've promoted Mark Black. Mark has been with us for about a year as an Attorney 3. And he is one of those folks who has been working those inspection cases. Mark has been responsible for all of the tow truck and vehicle storage facility inspection type cases for the last year. He will stay on that same team as an Attorney 4 and now be focused on consumer type complaints. So congratulations to Mark. His previous experience includes 2.5 years with the Caldwell County, I believe it was the, let me find the paper, let me not say this wrong.
Help her, Mark.
Caldwell County Attorney's Office, and he prosecuted misdemeanor criminal cases there. Mark also holds the rank of Colonel in the United States Army Reserve. Mark is in the room?
Congratulations. Thank you.
Another recent hire we've made was also an internal promotion. In the new FTEs that were granted to the agency, the executive office was nice enough to give us another FTE to be a second legal assistant to help with the ever-present load of criminal background referrals that we get from the licensing division. So we will now have 2 people serving that role, whereas up to now we've only had 1. We promoted Tanya McCullough to that position. Tanya's here. Tanya's been with us already in the enforcement division for 4 years as an administrative assistant in the prosecution section. She's very well acquainted with our procedures and our structure. She has, before her time at TDLR, she has more than 20 years experience in administrative support type work, including with the Real Estate Commission, First American Flood Data Systems, the Workers' Compensation Insurance Fund, and the Attorney General's Workers' Compensation Division. So this lady is a heavyweight, and we look forward to her in this newer role. Finally, I wanted to tell you about another internal promotion. In February, Tony Kubion left the Enforcement Division to also join the Executive Office in the section that's now called the Office of Strategic Relations and Communications, formerly known as Public Affairs. And we have promoted from within Chris Russey to fill Tony's former position as the Research and Analytics Specialist for the Enforcement Division. Chris is back here. Chris had been with us previously as an investigator in the Enforcement Division for about a year. Before coming to TDLR, he was with the Department of State Health Services for 5 years, first as an inspector and then as a training specialist. And in his time with the Department of State Health Services, he did a lot of the same stuff that I'm having him do now. You know, lots of statistics, lots of preparations of materials for public speaking engagements, things like the penalty matrix. So he's really picked it up and running with it. And that was all I wanted to highlight for you. I'm happy to answer any questions that you may have about my report.
Any questions for Christina?
Good job, Christina, bringing those numbers down. That's so great.
Yeah, that is fantastic.
Thank you.
But your staff knows they're doing an excellent job.
Yes, they're doing the work. I'm just the one talking about it.
They make you look good.
Yes, sir. Thank you.
Susan?
Thank you. Susan.
Hi, I'm Susan Stanford with the Office of Strategic Relations and Communications.
We need an acronym. We need an acronym.
Well, also we call ourselves OSRIC, OSRC, or the division formerly known as Public Affairs. We give that little tribute to Prince. Yesterday we had a wrap of some videos that we've been producing, and specifically there were 3 different videos.
Are they rap videos?
They were rap. Oh, no, but I should have thought about that one. They are going to, the audience will be the respondents to cases that you are hearing and to the public wishing to make a public comment. It will help lead them. We'll place the videos on the website, and we will also show them before the meeting starts here. By the videos being on the website, the people will be hopefully able to better prepare and know what they're coming in to present to you. And, you know, for instance, we're telling, you know, this is what you can say, this is what the commissioners can hear, and kind of give them a line, a guidance to follow. Because as you know, through your years of sitting on this commission, we've had people that just don't understand what can be presented during their hearings to you. And as I said, it will serve also as a reminder when we have it prior to the meeting, just so, you know, the last thing that they hear they'll be able to get their mind around it. Hope, you know, it may take a while for everyone to catch on to it, but we're excited about it.
And Susan, let me just throw in that my vision is that we will show those prior to the commission meeting starting. It's a recreation of what will happen when somebody comes forward for their proposal for decision, what information that they can bring forward when they talk about it, that it only is what has been discussed in the SOA hearing. Likewise for the video for rehearing. It will explain what things you can bring up as an error instead of just saying I want a rehearing because I want to go back and talk to you about everything that happened beforehand. So hopefully it will save the chairman from having to say over and over again, you can't say that because it wasn't said in the hearing.
Thank
or
you.
It's not a valid piece of information. So by showing that right before the meeting, people will have a understanding of what you're going to be working with them on. So I figured we'd use some of the technology that we had to try to streamline the processes.
And the subject matter will be motion for rehearing, contested cases, and public comment. I would like to take this opportunity to thank Ken Sharp, Mary Winston, Charles Johnson, Charlotte Melder, and Bill for writing the script that we were working with. And I did notice as Ken Sharp was testifying today that somebody needed to powder his nose and forehead. I want to thank him for being tolerant enough yesterday to put up with the crew powdering his face for him so he wouldn't shine in the video. That was very kind of him. If I missed anyone else,
Not physically shined, but shined otherwise.
yes, he had a certain glow to him at times yesterday. Anyway, if I missed anyone in my appreciation, I apologize to you. But I'm excited about this, and I think it's going to be a real benefit to the hearings. And I guess time will tell. Thank you.
And I appreciate it also. I think there's a lot of things that we're doing that's going to, as you said, benefit the hearings, but also benefit the agency. I know that I'm looking forward to this kind of new department, or OSROC, or whatever you call it, to begin to start really moving forward and bring more things out of it. You know, you look at that, and then the Office of Innovation that's been created, those type of things. It's the reason that this agency continues to stay in the forefront and stay ahead of what's going on out in the industry. And I think that's the reason that, you know, we continue to be looked upon by other state agencies as being innovative and moving in a direction. I think that helps. So I think I'm very fortunate to be a part of this agency.
Well, and I guess this is going to be a mutual admiration society. We appreciate everything that each of you do for the agency. We couldn't do what we do without your guidance. Thank you.
Thank you. Appreciate it. Thanks, Susan.
And Mr. Chairman, when I went through my presentation, Delia, would you stand up so that people can see who you are? Because I blew right through it without letting her stand up to be recognized. She and Tam will be the support for the advisory boards.
Congratulations.
Thank
you. Let's move on. Commissioners, real quickly, let's go to item U, which is discussion of the meeting dates. You have before you possible commission meeting dates. We have a commission meeting set for September the 9th. So that's the next commission meeting. Normally, what would have happened is that in June, we would have pushed forward some additional dates, but we missed that meeting. So right now, what we're looking at are these particular dates. If there's a problem with these dates, if you know it now, let us know. If there's not, we'll kind of set these as a tentative date as we go from the October 14th. If there's not a problem, we'll go ahead and set that date now. But look at your calendar for the 18th of November, January 6th, and February 10th. If there's a problem, let Kay know. If there's not, go ahead and pencil this in to your calendar, and unless we hear anything different, we'll move that from a pencil to a pen. So, October 14. At this point in time, I'll go ahead and enter into public comment. If anyone is here to address the commission, feel free to go ahead and come forward. If you fill out a public comment form, you will have 3 minutes in which to speak. So anyone here to speak, please come forward. There being none, we'll go ahead and close that portion of it. I do want to kind of do a couple of things. One of them is, I'm not sure if you know, if you're not, just get with Bill or Brian. I do want to send out our prayers and a comment real quickly to Jean. If you're listening or not listening, you'll hear it later on, but get well, my friend, and we hope to see you back at these meetings. So just continue to work hard and do what you're doing, so we look forward to having you back. Also, I would want to have Christina Guzman come forward. I think she's actually in the meeting, or at one of the offices in the back. So I'll wait for her to come forward.
She's in
So
the snow-filled room.
yes, she's actually probably listening to this and refusing to come out because she doesn't do crowds very well, she's told me.
I think it's actually snowing in there right now.
Is it?
Yeah, I think so. I walked by.
Actually, it's snowing. It's a
I
little
think
cold
I
in
saw-
there.
Yeah, I did. I think I
Well,
saw
I
white flakes.
think it's about to get colder as she steps out. For those that know Christina. Christina has submitted her notice a while back that she'd be leaving the agency. I think now technically her last day is, there she is, as she comes in. I told you it was getting a little cold in here now.
The last commission meeting.
So this is her last commission meeting for the agency.
It's not my last, because I'm going to come back and give you the what for.
Her last official day is August the 28th, is
Yes,
that
sir,
correct?
that's correct.
This is her last commission meeting, because the next meeting that we have, she'll no longer be with us, unless she comes in for a public comment, which she stated to me she will. But I've had the pleasure of working with Christina for the last 10 years, as she was in the office, the executive office. I can tell you it's been a pleasure, it's been a joy. She makes it fun. I tell you that we have had our jokes back and forth.
Yes.
So I made it a tendency to leave a little note for her every time I came by and just say I was here.
Yes.
And so the last probably 6-7 months, she's been working kind of on a part-time basis.
Yes.
Coming in only a couple of days out of the week. So those that have known Christina all these years will know how the joy she was to the agency. I think that probably Commissioner Moses, Commissioner Morgan, and myself are the ones that know her the longest.
Yes.
So, but you will be dearly missed by this commission.
Thank you very much. Appreciate
So-
that.
So, any comments that you'd like to make?
No.
Yeah, that's Christina right there, folks. That's Christina right there.
Thank you.
She'll be working actually at her church.
That's
So,
correct.
Very good.
she'll be doing that. So, Commissioners, I don't know if you have any comments for her. She loves to hear them all.
We'll have to come see you. We're going to miss you.
Oh, thank
You did a
you.
fantastic job.
Thank you very much. I appreciate
It's
that.
been a joy getting to know you, Christine.
You too. You too. I've enjoyed working with all of you.
Including the chairman.
Well,
Even Mike?
yes, I have.
Come
I
on.
have.
She actually
I'll just
misses
put it on
Frank, too.
record that he's going to pay.
Yeah. Frank, if you're listening, I think she misses you more than I, so. But thank you very much for everything that
Appreciate
you
all
did.
Of course. Yes, sir. Thank you very much.
Thanks for all your
Thank you.
You're welcome.
One final thing, has Brian made it in yet? Brian has not made it in, so he's just gonna have to miss it.
Yes, sir.
So, we do have, actually, if Bill will come forward. Bill has been with the agency for 15 years.
Wow.
So, we want to recognize Bill. Thank you so much for everything that you did. Thank you. It's a recognition on behalf of the agency for the work that you've done. You have led us and you have grown us, and we are a much better agency because of you. So thank you for your dedication and your leadership in this agency. So I know that we wouldn't be here if it weren't for you, and we wouldn't be here if it weren't for Brian. And I know that I would not be in this position either had I not had the guidance of you and also Brian telling me which direction to go, what to do, and keeping us informed of what we're doing. I think that you and Brian are the primary reasons that we are the darling of the legislature. They trust you, they trust Brian, and they respect your opinion and everything that you bring forward. So I want to thank you personally on not only my part as a chairman, but also as a friend. Thank you for being that friend to me also. So,
And this is a real surprise because Brian and I normally present these longevity awards to our staff, and I hadn't even thought about this.
so, yeah. Well, I've been, a part of Christina is that she's been hitting me up on this from the beginning. So she's made it perfectly clear that I was going to be presenting this today. So, Commissioners, I'm not sure if you have any comments to make.
Well, I don't think we would be where we are today without you. You know, when I think about when I first started and how small of an organization we were and
Yeah.
how much we've grown over the last 12, 13 years. I guess we're about 200 employees.
And one campus.
Yeah.
On one campus.
When I came in, we had
140.
168.
Yeah, so when I came in, it was 140. So
Yeah.
look at how much we've grown since then. It's just amazing.
Well, one of the things that we talked about yesterday in the book club about how the mighty fall was to not confuse that I'm so good, but sometimes I'm lucky, and we've been very, very lucky. We've been able to take advantage of the good fortune, but there's been a lot of luck in the success that we've had.
Yeah,
So we don't ever want to forget that.
Exactly.
It's just been amazing how we've grown and how it's just, you seem to just glide into everything as we just continue to grow. It just glides, you know, it's so smooth. And that's what has amazed me every year as we grow bigger and bigger. It's just such a smooth transition into everything. And I really admire you for it.
Well, it's fun to come to work every day.
Yeah.
Commissioners, anyone else?
Okay. Also, I said, you know, being around all these years and working with you, I tell you, it's a pleasure. Your leadership and leadership. We've been around other agencies, and it hasn't been as pleasant. So thank you.
Yeah.
Thank you.
I think from my end, I think it's refreshing to see government run like a business. I think this, for those that are listening, you know, when you see an agency do what the private sector would do and even do it better, and I'm a leadership junkie, and I like stuff, you know, I like to read stuff, and I think Bill has done a wonderful job trying to portray not only his walk his walk and talk his talk, but I think he's done a wonderful job making sure that his staff is trained to do their job, so thank you.
Thank you.
Thank you very much.
Yeah, I'd like to say something. Everybody has talked about how great you are as a leader here in the agency, and I echo that, but also the humility that you display in every dealing I've had with you, the kindness, and you never think of yourself as the end-all be-all. And I think that speaks volumes to who you are as a person and what you've been able to accomplish. And so I just don't want the individual to get lost in all the accolades, because you truly are a wonderful individual. Thank you. It's been a pleasure getting to know you.
So, also, just so you know, I think that Brian came over just right after you did, and he's not here. Yeah, about 30 days behind you. He's unfortunately has been detained, so the only thing I would say to Brian is I have yours here, and I would just say ditto.
Ditto.
That's right. Since you're not here to hear it, so.
Our successes have been because of the team Brian and I have been.
Yeah.
Right.
And the thing that we talked about is that Brian and I have been working together longer than I've been married in my life.
Yeah, we probably don't want that out there, but it's there already, so, you know, you can't take it back. We're on video.
I love it.
But great. And we do have Brian's also, it's for 15 years of service with TDLR, so he'll get that whenever he decides to walk through the door. By that time, the meeting will be over. So, I'm sorry?
When he decides to work.
Yeah, when he decides to come into work. So, and I don't know when that'll be. But that being the case, I think that we will end this meeting on a high note. I believe we've covered everything that we needed to. So, unless there's any further business coming before this commission, this meeting is adjourned.
Thank you.